Fifth,
This item 50. Last section they mentioned, my lord, the IAS, my lord, he has not transferred the record. May I see the process on record?
I is not on record.
My lord, not on record. It is not tagged in because there was some delay in going back the files. That's why. I pursued my level test, but it could not.
Item number AF, let it be listed again on 5th of April.
Lord.
5th of April.
April, my lord. Hello, the might be on 18th, my lord. That's not difficult. 18th. Oh, like.
My lord, as per item number 41 is concerned, you cannot like to take this method because of item number 41, because of the respondents.
Before any other bit.
Like,
May I please, your lordship? Lordship, item number 52. The petitioner want to withdraw ticket.
50?
Transfer petition 63 of 2023. Okay.
What do you want,
Withdraw the case.
Mr.?
Amicable settlement is going on between
Your
the
name?
Lord.
You are not there?
I mean, color no.
Your name is there?
Yes.
Mr. So-and-so appearing on behalf of the petitioner submits that he has instructions to withdraw the instant petition. Accordingly, the transfer petition
Transfer.
stands closed on withdrawal. Interim order, if any, stands vacated. The code below, the learned code of
Udalguri, your litigant is on the Udalguri.
shall proceed with the same proceeding being titled being what is the stay?
Transfer.
Wait.
Divorce petition.
The learned counsel appearing on behalf of the petitioner, Mr. So-and-so, submits that he has instructions to withdraw the instant transfer petition on the ground that there are certain amicable on the ground that he has been duly instructed to do so. So taking into account the above, the instant transfer petition stands dismissed on withdrawal. The interim order dated 21/7/2023 stands vacated, and the court of the district and session judge Udalguri shall proceed with title 2 bracket D in case number 04/2021 in accordance with law. The interim order also stands vacated. The registry shall bring the instant order to the notice of the learned court below.
May it please to lordship. I am the respondent, my lord. My petition, right? Some problem, my lord. I leave the court, my lord. So, my lord, that may be taken up next week.
What? Item number?
Item number, my lord, 37, my lord.
one of the respondents, two respondents explained that. So, the two sets of the IA for abatement and
What are all these applications? What are all these applications?
there are 5 so there is delay in filing the substitution petition, one instant petition, and also will on abatement.
So you want an adjournment?
My lord, next week.
At the request of the learned counsel appearing on behalf of the respondent, the matter stands adjourned to be listed. after 3 weeks.
Huh?
Huh?
8 or 9.
Why?
8.
No.
Long pending.
After 3 weeks. Next. Yes, Mr.
Also, as per instruction of my client, I want to withdraw item number 11, unconditional withdrawal. I also inform opposite party. No stay order is there.
You want to withdraw?
Lordship.
Mr. R. Ali, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant application. Accordingly, the instant application stands closed on withdrawal. Interim orders, if any, stand vacant.
That's it, Your Lordship. Your Lordship, I beg to mention one CRPIO for listing audit. Kindly the method listed on it.
Yes, what has happened?
Lord, after the last order, my lord, we were invited for a meeting.
Very well.
Proposals were
Something
floated.
is
Well, with all sincere apologies, because my lord, what had happened here, my lord, on 19/3/24, I made a submission before this court.
Uh.
That, my lord, none of the representatives of the petitioner side has turned up on 1/3/2024 because they were totally clueless. And my lord, we have filed an affidavit. In fact, my lord, the petitioners have also filed an affidavit. Those are, my lord, flagged as flag E and flag F. Flag F is our affidavit. Now, my lord, on
okay. When are you having the meeting?
my lord, 2 meetings already done, my lord, and now, my lord, if my lord may be pleased to,
Let us have it immediately after. Let us have it on 29th of April.
my lord, can it be on the first week of May? Because if we have some breathing space, my lord,
When is the election out here?
election, my
Amin
lord,
Gaon?
it was-
Because she is the DC is the district election officer.
yes, just a minute, my lord, my lord,
Amin Gaon will be here.
I mean,
It will be on 7th of May.
9th, yes, 7th May, 7th of May,
7th of May. So we'll have it on 13th of May.
13th of May,
Just
my lord.
one thing, otherwise, my lord, there's proposals have been floated. So the deputy commissioner in her minutes has recorded that since it's a huge parcel of land, perhaps it cannot happen in her level, and she wants to forward it to the revenue and PF department.
Let us see once she comes up with a report, what has fructified in the meeting. Let it be placed before this court on 13th of May. Then we'll take it up with the revenue authority.
My lord, can you record it?
Why?
Because we will also
Otherwise,
have to,
this
we
is
will
why.
also have to file one additional supplementary affidavit, my lord, taking on record entire thing.
No, whatever you
Yeah,
do,
yes,
do.
yes.
But the thing is that on 13th of May, I'm keeping it so that on that day, the deputy commissioner shall file an affidavit as to what has fructified in the meeting and what is required to be done.
What is required?
Now,
to
once it is being brought to the attention, then we'll take up the follow-up action.
do? Absolutely.
Right.
And since, my lord, those
Because here, Mr. Teka, kindly appreciate, one has to now take up, one land was allotted to you, which has now gone on auction sale. And after that auction sale has happened, whether notice was issued or not, that is another aspect, which is also a very big. And third party rights have now been accrued in that land, which was allotted to you, or which was kept as a ceiling reserve. Whereas the other land which you were in occupation, that was not given to you, but you are still in possession of that. So let's see what happens.
But as a matter of fact, if we can bifurcate the two claims, and Patta number 9 is dealt with here, and we are left with liberty to pursue with maybe compensation or likewise. If it's good for the
Let us not go beyond what your case.
we will file an affidavit bringing on record the present status.
Pursuant to the order dated 19/3/2024, both the petitioner as well as the deputy commissioner, Kamrup Amin Gaon, have filed their affidavit on 30/3/2024. This court have duly perused the same. It has been also brought to the attention of this court during the course of the hearing that already two rounds of discussions have ensured pursuant to the orders passed by this court. This court is also aware of the fact that the Lok Sabha elections is fixed on 7th of May. And as such, there might be some difficulties in concluding the discussions in the meanwhile. Under such circumstances, this court fixes the matter on 13th of May 2024, on which day the Deputy Commissioner, Kamrup, shall bring to the notice of this court as to what has transpired on the basis of the discussions so carried out, and further what is required to be done so that the matter could be brought to a logical conclusion. Just the court. But it's already this matter. After all these things, no judge will take it up.
Obliged.
I'm so obliged.
Yes, what is this?
My lord, we filed an application on order 7/11 for rejection of a plaint. That was disallowed. Before that, my lord, we filed Ganga Vishal Agarwal was holding annual patta land by the government has given him during his lifetime. We were possessing. Ultimately, after his death, it got transferred back to the government because annual. So ultimately, it goes to the government. Now, when it goes to the government, we were possessing. So we filed because the opposite party were trying to enforce it. We made an FIR before the Dibrugarh PS. Now Dibrugarh PS has before Duliajan PS and they registered a case. And it was a non-FIR. It was sent to the ATM. Now ATM decides the case. The second party appears and they file written statement. Evidence was taken. It was declared that it was in my possession. Now they went before the Sessions Court. Sessions Court, my lord, set aside the order. We came to the High Court. High Court remanded. And ultimately, High Court finding is that the ATM's order was upheld. We were in position. Now, they now have filed a suit before the learned court below, before the learned trial court, civil judge. Now, they sought for a declaration. They are owner and possessing the land. Now, we file a suit. We file an application under Order 7/11, saying that when a declaration has been sought for as an owner under Section 34, how you can, because you have to make government as a party. Ultimately, it's a government land. It's a government land. You are possessing. You say that you are possessing. It's a government land. So you are claiming an ownership over the land. So that was our case that non-joinder of parties by the government is fatal under Order 7, Rule 11D. So this to be rejected. It was heard by the learned court, and ultimately finding is that the learned court is saying that the cause of action. The position is a question of position.
No, Mr. Das, are you going to withdraw the petition or what? Should I dismiss it? Which one?
No.
It's a case of non-joinder parties.
No, why not?
It's absolutely whether he is entitled to know or entitled to raise. Kindly see his plaint.
Yes.
Kindly come to his plaint. What is he asking for? For declaration and for permanent injunction in his favor, restraining the defendants not to illegally and forcefully dispossess him. Meaning thereby he is in possession.
No, let it be. I'm not, but only kindly see 44. Page 44.
Yes.
Page 44A. For a declaration of plaintiff of the absolute owner and possessor of this suit land, and for a permanent injunction.
So for that the suit will be dismissed on the ground of non-joinder of necessary parties.
But my lord, what I'm saying, that why unnecessary is suit? Because if he
Why the unnecessary suit is you have been given a very fantastic ground out there that without the state being made a party, the suit cannot be decided. Because the land which he is asking for, he cannot. Yes, he may not, in the eventuality, he may not win the case, but that cannot be a ground for striking out. He's in possession. He's asking that you are disturbing his possession.
That's a different thing order, whether I am in position or he is in position. That's I agree to it, my lord. It is the court who will decide. But what I want,
Mr. Das, has your junior given you the Liverpool judgment?
no, I have got your lordship one judgment.
Oh, forget
Yes.
about mine. Have you
Yes.
seen the
No.
Liverpool judgment?
Yes.
Liverpool judgment.
Yes.
And Liverpool, kindly come to
judgment,
paragraph
2004,
151.
151.
One.
In ascertaining when the plaint shows a cause of action, the court is not required to make an elaborate inquiry into doubtful or complicated question of law or fact. By this statute, the jurisdiction of the court is restricted to asserting whether on the allegation a cause of action is shown. By the express term of clause, now one judgment was cited. By the express term of Rule 5 clause D, the court is concerned to ascertain where allegation made shows a cause of action. The court has not to see whether the claim made by the petitioner likely to succeed. It has merely to satisfy itself the allegation made in the petition, if accepted as true, would entitle the petitioner to the relief he came. If accepting those allegations are true, no case is made out for granting relief, no cause of action would be shown and the petition must be rejected. But in ascertaining whether the petition shows a cause of action, the court does not enter upon a trial of the issue affecting the merits of the claim made by the petitioner. It cannot take into consideration the defenses which the defense may raise upon the merits, nor is the court competent to make an elaborate inquiry into the doubtful or complicated question of law or fact. If the allegation in the petition primarily shows a cause of action, the court cannot embark upon an inquiry whether the allegation are true in fact, whether the petitioner will succeed in the claim made by him. So long as the claim discloses some cause of action or raises some question fit to be decided by judge, the mere fact that the case is weak and not likely to succeed is no ground for striking it out. So,
Purported
the
failure.
purpose failure of the pleading to disclose a cause is distinct from the absence of full particulars. So,
It is
only
a
one
case.
thing.
It's a case whether you see, a very pertinent question arises. He claims that he is in possession of the property.
Correct. That's
And he claims that a permanent injunction be given against you not to disturb his possession.
absolutely there is no problem on it. But only what I am asking myself, that when you are seeking for a declaration as an owner,
He may not be entitled to a declaration. Let us assume
no,
he may
suppose-
not. But
suppose-
is he entitled to a
if
permanent
he is
injunction?
not entitled for a declaration, then my next question will be that whether section 34 of the specific relief, whether he is entitled to get the relief or not at this threshold of.
Let us assume he is not entitled to declaration.
So, my lord, it is. if
But is he not entitled to protection of his
No,
possession
no.
against you?
No, possession also, some trespasser also can come to the court of law. Like urban area rent control, like your lordship is aware, the trespasser also I cannot be evicted without due process of law. The suit will be filed. But here, on the face of it, how your lordship dealt with that case, you kindly just look into it, the judgment of your lordship, that's the latest 2024. Law of limitation, your lordship on the
Limitation is different.
No. That's under order. I understand limitation is different. But here, what my point is here about section 34 of the specific act, where if it would have been your simple case that he should be protected, so far he is possessing the land, and for a permanent injunction, you may not sought for under order 39 rule 1 and 2 because you are asking for permanent. He has not sought for order 39 rule 1 and 2. But wherever a declaration is being sought for, that he is the owner. So I am asking myself a question that whether it was his duty, because under section 34, he is claiming a relief for a declaration. He may not. His simple case would be, yes, I am in possession, so he should be protected. The declaration should be protected for possessing him. That no one should be, the other side should not disturb. I understand. But what about section 34, my lord, relief?
How does section 34 bar?
No, he's asking for a title. The absolute owner.
Understood. Let us assume, Mr. Das, that he is not entitled to declaration. Let us assume. Is he not? Then also doesn't his suit remains
No, but
on the question of permanent injunction?
can I just point out this, my lord, I'll answer to your lordship that query that you have your prayer in the plaint is that you are seeking for a declaration. That's my whole case. My lord.
Understood. Let us assume that he is not entitled to injunction.
Then, my lord, then, my lord, what will happen? Then the case will fall.
No,
Because you are
his
seeking
case
for
would
it.
not fall.
Because-
His case, he is in possession, his case against another person would obviously remain that he should not. Yes, the state may be with the owner, the state he cannot ask for. Yeah, his declaration, if at all, would be a declaration in person and not in rem. Okay.
I just have gone through some few judgments of the court, of the Honorable Supreme Court as well as our High Court in 19 something very old judgment. That
Which one?
my lord, it's 1975 USCC page 144.
What does it say?
Yes, sir. Yes, sir. This is for a copy for the court.
Yes.
And it's the para 4, my lord. Before we proceed to consider merits of this contention, it seems to us suit for possession must fail on a preliminary ground, as asked by Mr. Bal, counsel for the respondent. In the plaint, the plaintiff in his case asked for a declaration that the auction, sale, and the conveyance are both void. Giving effect to the contention means that the lease in favor of so and so remains live issue lease, and Barsi Mills continues to be a tenant of the land. If this is the position, the suit for possession are premature because the lease for 99 years have not yet run out. Further, the declaration asked for cannot be made in the absence of liquidator representing Barsi Mills. But Barsi Mills have not been impleaded in the suit. It is well known that a company, until it dissolved, retains a distinct entity, though in the case of company liquidating the administration of affairs, possessed or liquidated clearly.
Mr. Das,
Yes.
this judgment is a fantastic judgment for you in the suit trial. Because the decree, it was a decree against the decree.
But I thought that I will take that benefit before this court only on the ground that they have not made. See, Your Lordship, this is I agree. I agree to the extent that possession, yes, of course you can come. But when you sought for a declaration as a owner, my lord, I thought
He may not
proper-
be entitled to, but can this court now partly reject a part of the plaint? No.
But Your Lordship decided that was a law of limitation. I have seen that.
That is on the different
2024.
aspect.
Discuss the entire some judgment of the Supreme Court also. Can you
See,
see that
The
judgment?
judgment which I have rendered on the law of limitation is
Yes.
that person concerned have filed the suit. Initially, his suit was within time. That suit was dismissed dismissed for default. Thereafter, that was a suit for specific performance, stating that on that very date he had he came to know that the defendants have is not interested in following the particular the agreement. And as such, Article 54 comes into the play.
Like I have
And then that suit, after 6 years, he files another suit. So therefore, on the face of it, when the earlier suit was filed, which was dismissed for default, he came to know on that basis, and that 3 years have passed. And as such, I applied that Order 7 Rule 11B. But how do you apply here?
this is only on it. There is
You have a
but
very
what
good case in the
I'm
trial.
asking-
But
Yes, but I am asking by the settlement holder. Their settlement, this settlement holder, what right has got when it goes back to the government? It goes back to the government.
Mr. Das, I can do you one favor.
Yes.
I can only adjourn the matter today to be listed after 1 month. When I may not be sitting, you
No,
may
no,
be
that I
entitled
don't
to a
want.
notice.
No, that I don't want.
At the end of the day, again, it comes back, I'm going to dismiss.
No,
Nothing.
that's, my lord, I don't want that it should be adjourned.
This is a pure and simple case for dismissal of your application. The court could not have done that. The moment
No,
if the
court has
court
not-
have done it, then automatically one has to interfere with that. Whether you have made whether non-joinder of party can be a subject matter of a Order 7 Rule 11? No. Today, tomorrow, you have raised all these things. He may file an application under Order 1 Rule 10.
Yes.
So impeding the state. Then you may come up again and say that, look here, Section 80 has not been complied with, which is mandatory. Then obviously one may look into it.
So that's true, my lord.
Not
But
now.
what I thought that this is a declaration which you have fought for and you have not.
No,
made
your thinking has
it as a
been
part.
is a very noble thing to think about it on the basis that why should the court out there spend unnecessary judicial time in a suit which may not at the end of the day
Why not?
result in a favor of them. But you
That's-
see, what do I do with Liverpool?
So that's why nip of the bud, my lord. Your lordship knows that nip of the bud, it should be finish it off.
You
my
see, in the nipping of the bud, if you see that 1977 Supreme Court judgment,
lord. Yes.
and more particularly at paragraph number 5, it categorically says the nipping of the bud should be done strictly by following what the mandate of Order 7 Rule 11.
That's true,
Then,
my lord. Order
Here,
7
it does not come
only
within the
what
ambit
I-
of Order
but
7
it
Rule
was
11.
not specifically, but I thought that Order 7, Rule 11 D is in respect of that is barred by. That's only what I thought that yes, it is not maintainable on the ground, but they did not.
It is not maintainable. It
it
may
is
not
not
have a cause of
maintainable.
action.
My lord, non-disclosure of a cause of action, that there may be a cause of action so far as possession is concerned.
So then,
There is no.
then
the- all the
but
argument
the
on-
Supreme Court has been very clear on you cannot bifurcate the suit. You can't partly reject the plaint. So what do you want? A long judgment
No,
or a dismissal or the favor which I can do to you?
that I don't want. That will be again troublesome after waiting for 1 month. I don't want.
After 1 year again.
No,
the
no,
thing
I
will-
don't. Again, same thing will happen.
But the problem is there must have been some injunction given,
no,
trial court.
they did not file any application on Order 39. They did not file. They know, because again injunction, because again the government will come by law. Order 39, Rule 1 and 2.
Hmm.
You have to make government. They did not because we are saying we are in possession. That's a different thing altogether.
Hmm.
And there was we have given all the orders of the High Court also how it proceeded, and we were in possession of this premises. We have done it. We have given it in our. But one order, my lord, will kindly see. Page 35, kindly see, my lord.
Hmm.
That your lordship can definitely in a suit has to be there. Page 35. Ground 10 we have taken. Page 35. There's a High Court's order.
Yeah.
It is clear from the material available on record that parties have entered appear before learned ATM. While a written will laid their evidence on the basis of such evidence. They came to a conclusion the first party was in possession of dismissal on the date of preliminary order according directed material sanctions. But that's the order of that was an upheld. But that's your lordship will not decide here.
That is
Or will
145.
defer the trial court.
Only for 2 months.
Yes. But that we are in possession, but that your lordship will not decide here.
No, you see, if you see the plain,
Yes,
kindly see.
Yes.
One has to, if you see Order 7 Rule 11D,
yes.
the words used is from a reading of the plain, statements made in the plain, whether the suit is barred by law. Now kindly see paragraph
Paragraph
18,
18.
21,
18.
18,
Yes.
page 42.
Yes.
So the
The
defendants want to
to
illegally dispossess the plaintiff from the suit land and the plaintiff's property forcefully by creating the atmosphere of terror which so and so. Then paragraph 21, the defendants with their men came to the site of the Iman and openly extended threat that he would damage and destroy the house and dispossess the plaintiff from the suit land and forcefully occupy the suit land. Hence, necessity of the present suit for a permanent
But
injunction.
that it is absolutely, I agree with your lordship. That I agree. Only what I was on under section 34 of the specific relief.
He
Act.
may not be entitled to her.
Yes, that's not.
He may not, but
Yes.
that cannot be a ground for dismissal, rejection of a claim.
Your lordship will. I need what by your lordship. That's my argument.
What do you want?
No, no, it's your lordship. Pass it on.
No, I'll pass the order. What do you want? A long judgment or a short one?
It should not affect the trial of the case. That's all. That's all. It should not affect. We-
Heard Mr. T. Das, the learned senior counsel, assisted by Joinder. This is an application under Section 115 of the Code of Civil Procedure for short the court, challenging the order dated 16/2/2024, passed in Mize case number 83 of 2022, arising out of title suit number 30 of 2022, whereby the application filed by the court of the civil judge Dibrugarh, whereby the application which was filed by the petitioners, were the defendants in the said suit for rejection of the plaint under Order 7 Rule 11 of the court, was rejected. This court have duly taken note of the provisions of Order 7 Rule 11. The entire thrust of the case of the petitioners herein, that the suit so filed by the plaintiffs was, from a perusal of the plaint itself, was barred by law. And as such, the plaint ought to have been rejected under Order 7 Rule 11D. The submission made on behalf of the petitioners is that the plaintiffs in their suit have sought for declaration of their right, title, and interest, as well as for permanent injunction. Against the defendants. It is the case of the petitioners that the land, the suit land, being admittedly a government land, how can you say it to be a government land?
Yes, annual patta, it went reverted back to the government. Kindly see.
No, understood, but it is PP number.
No, kindly see this order. Kindly see this order. Page 54, Mike. Page 54. They have concealed actually. Kindly see. Page 54 in the top. After this 53, down below. The said so and so, which is evident. A mutation so and so AP land standing in the name of one. And this circular has forwarded the applicant deputy commissioner for cancel and restore the dispute land as a government land. Accordingly, so and so cancel the AP number so and so.
No, but they are asking, this is PP number.
This is, I don't know how they have, this is PP. But 54, it's a government land. 54, kindly see mine.
Yeah, I had submitted that illegally. The suit land was a government land. And and to that effect, the learned senior counsel appearing on behalf of the petitioner has drawn the attention of this court to an order dated 26/4/2016, wherein the district magistrate Dibrugarh, the additional district magistrate Dibrugarh, have in its order dated 26/4/2016, have referred the said land to be a government land. However, this court, while perusing the copy of the plaint, which is the only requirement for deciding an application under Order 7 Rule 11, it reveals that the plaintiff claimed to be occupants of land measuring 11 bighas 4 katha 3 lechas covered by DAG number 292 of PP number 34 situated at Boragadhoi Gao bracket Tipling Moja under Tengakat Revenue Circle, Dibrugarh. In paragraph number 2 and paragraph number 4, it has been categorically mentioned as to how the plaintiff acquired rights over the said land. It is further seen from a perusal of paragraph number 15 to 21 that the defendants are trying to dispossess the plaintiffs from the suit land, as has been alleged. There is no mention in the plaint that the land, the suit land, is a government land. In fact, from a perusal of the schedule to the plaint, whereby the suit land has been described, it is seen that the land has been described as a land measuring 11 bighas, 4 kathas, 3 lechas, covered by DAG number 292 of PP number, bracket periodic patta number 34. On the basis of the said, the plaintiffs have sought for declaration of their right, title, and interest as the absolute owner and possessor of the suit land and have sought for permanent injunction. In the backdrop of this above, if this court now takes the application, takes note of Order 7 Rule 11D, it would be seen that from a perusal of the plaint, that in order to invoke the said provision, the plaint, in order to invoke the said provision, the statements of the plaint, that from a reading of the statements of the plaint, the suit has to be barred by law. Under such circumstances, as from a perusal of the plaint, it does not disclose that the suit land is a government land, or for that matter, is a common land. The question of rejection of the plaint on the ground of Section 34 of the Specific Relief Act 1963 is completely misconceived. This court further finds it very relevant to take note of that in the application, while considering an application under Order 7 Rule 11, the court is only required to look into the statements made in the plaint as well as the documents relied upon. The order dated 26/4/2020 to 26/4/2016, passed by the Additional District Magistrate Dibrugarh, being not a part of the plaint, the same could not have been taken into consideration by the trial court. Under such circumstances, now, in the backdrop of the above, if this court duly takes note of the order dated 16/2/2024 passed by the learned trial court in Ms. case number 83/2022. This court is of opinion that the learned trial court have duly applied the law in the proposed perspective, for which the instant petition stands dismissed. However, in the full facts of the case, no cost is being imposed. It is, however, this court, before parting with the record, this court, however, observes that the instant order has been passed in relation to an adjudication under Order 7, Rule 11. And as such, the observations so made herein shall not affect the decision of the trial court in the suit. Yes, Mr. Savila, what are you challenging?
Well, the challenge, the context for 7 buses is valid up to 10/1/25 and 1 bus is valid up to 15/5/25. Well, in the meantime, they have issued a tender for 10 buses. And now I came to know that I shall be useless by the administration. Or the respondent who has been given the LOA for 10 buses in the tender, now he filed an application in the suit as well as in the case for arraigning him in the past. But
Who are you?
I am the existing contractor supplying buses to the.
You filed the suit.
I filed a suit.
What is your suit for?
My suit is my bus could not be replaced till my contract is ready because my contract has not started.
Then
So that is the suit matter.
that is your suit.
Yes.
Purva Industry
So
Uttam Purva
see,
against Delhi Public School.
Page 32 the prayer.
And then who filed this IA?
I filed by the new tenderer who has been selected for the 10 buses LOI in his paper.
Have you got a stay on the tender?
No, tender, not tender. I could not be replaced. These 8 buses could not be replaced. That is what this honorable court passed an order and it was demanded back to the trial court and the matter is pending before.
So why are you aggrieved?
Well, because this you person, he has no location so far my contract is concerned. He can run if additional new buses are given. Suppose now 10 buses they have tender has been issued. 2 buses, I have nothing to say. I have 8 buses. And if they want 10 more buses, I have nothing to say. I mean, but 5 buses.
How are you affected by them?
Hello?
How are you affected?
Well,
If the court has exercised the discretion.
he is not a 11 party melody here.
Huh?
Not a 11 party melody. Because he is right under new contract. I am existing contract. If my contract is time that's
But what do you say about clause B of your relief sought for, page 32? The petitioner, the respondent herein or whoever it is, the person who filed the application is a beneficiary of these two things. Then how do you say that?
So my question is, my 8% should not be.
But your prayer is not for that. Your prayer is not. If your relief is being granted, tomorrow they have been therefore although he have purchased all these 10 buses or whatever may be, he is not in a position to supply because of the fact of the ongoing litigation. That is why he wants to come, because he is a beneficiary of these two. Is he not entitled to support his action, being a part of it?
But 2% sometimes I have nothing to say, madam.
No. What do you? Have you given up the B and C in your plaint? How do you take care of B and C?
That's right.
Without doing that, the trial court is right. Because more particularly, Mr. Taiwala, one thing one has to know, these are commercial suits and the trial court has to urgently deal it. If any stay is given here, you'll have an far-reaching consequence. In fact, you will be more at law. Because unless you amend B and C and say that I am only not to give this, if your relief was that whatever they may do or go ahead with a notice inviting tender, but that notice inviting tender should not affect your contract. That was a different prayer. That is not. But you have asked for the entire thing. I think better withdraw. Or should I dismiss? Withdraw.
Party my lord, they do suppose the court for amendment of case.
You'll file amended. The learned counsel appearing on behalf of the learned Mr. G. and Saiwala, the learned senior counsel, assisted by Mr. Joinder. The learned counsel appearing on behalf of the petitioner, the plaintiff, submitted that taking into account clause B and the reliefs at clause B and C of title suit number of commercial suit number 02/2023, he is not pressing the instant petition. Accordingly, the instant petition therefore stands closed on his withdrawal. What is the next date fixed in the trial court? 5th of
April.
Who are you?
I am for respondent number 1.
You. One. That person is not here, na?
They have filed a caveat.
That person?
Yes, they have filed a caveat.
The caveat is not here.
It is there. It is there. Our caveat has not been packed. Their caveat has been.
And their caveat, they are not here.
Not here.
This court, according to stance, before closing, before parting with the record, disclose opines that taking into account that the new defendants have been impleaded in the said suit, the trial court shall said suit, which is a commercial suit, the trial court shall decide the said suit within the timelines as permitted under law. Huh?
Pay for amendment matter.
Then you can very well go there. Huh? I give you a liberty now.
Oblige.
Yes, Mr. Nath, what are you challenging?
Lordship file implemented order page 52, man.
Wait,
Page 52.
what is this? Order 20, Rule 18, read with Order 21, Rule 26, praying for rectify. Pattern of the 20, Rule 18, What do you want?
Lordship, the prayer of the petitioner was that, my lord, the scheduled land. The scheduled land is the, my lord, disputed land, which the boundary of the scheduled land is very much different, my lord. In the plaint and the report of the Latmano, it is Lordship will find page 53. That is not telling, man. So regarding execution of decree, I am being really affected. My land is there, my land is there.
Mr. Nath,
Sir.
did you raise all these objections in the trial court? Identification of the land? Did you raise it?
That was not because, my lord, because it was actually not a purely partition so. But in the plain,
No.
Lordship
Did
will-
you raise the issue as regards the identification of the land in the trial court?
no, man, no, that was not.
These things can't be raised out.
Because since, my lord, as per schedule of the land, man, the decree is to be executed as per the schedule.
You see, the trial court shall execute the decree exactly as per the schedule.
Yes, man.
So that is it. The trial court shall proceed, the executing court. That's all. They can't go behind the decree.
Yes, my lord. But here the regarding the deputy commissioner while executing the decree is a partition suit, my lord. Receipts or dispute for the deputy commissioner. And
Was
Monroe
it a
is to-
partition suit?
Yes, my lord. Partition, right title declaration and partition.
Where is the degree?
The lordship will find plaint. Your lordship will find plaint. Your lordship will find the suit for page 15, madam.
It was a suit for declaration of right title interest over the suit land. Where is the
And
partition?
also, my lord, partition also there, madam.
Where partition? Oh, partition. Let a decree be prepared. Decree declaring that plaintiff has got right title and interest over a Schedule B land and accordingly over Schedule C and accordingly a precept to the revenue for creation of a separate DAG. A creation decree declaring that the main defendant are trespassers in Schedule D land and so and so. Yeah. Oh, no partition.
So, my lord,
This is not a partition decree. This is a thing that the once this is properly identified within the boundaries, they'll issue a separate patta. This is the different aspect. That is not a partition.
in that case, I have no objection. But in spite of that, my lord, they are going to partition the land.
There's no partition.
Yes, my lord. There is
No.
no.
You did not raise, they have made definite boundaries in the schedule.
Lord.
Schedule B and Schedule C has definite boundaries, which is
Okay.
duly noted down by the trial court. So executing court. So nothing.
So in no schedule, my lord, I am nowhere in the boundary map.
Very well.
The defendants are nowhere boundary, but
Yeah.
it is mistaken by the map. Trust me,
A
has
trace
been
map
wrongly
was
prepared,
also
ma'am.
prepared and I have perused the same. Now it is fairly settled that an executing court cannot go behind the decree. Moreover, as correctly pointed out by Learned Counsel, no dispute was raised during the trial court proceeding. So we dismiss this with a cost of 25,000, which was given by the Supreme Court in 2003 ATC, Ravinder Singh. What do you say?
I'm not challenging the my lord.
No,
regarding this.
this is not done. You have two options, either withdraw or dismiss. Which one do you want? There is no case made out.
No, my lord, that I have to withdraw, my lord, and I have no.
Mr. S. Nath, the learned counsel appearing on behalf of the petitioner, submits that the petitioner this is an application filed under Article 227 of the Constitution, challenging the order dated 28/2/2024, passed in Ms. case number 80/2022, arising out of title execution case number 29/2017 by the Court of the Civil Judge, Junior Division Number 1 at Borpeta. Full stop. After hearing the parties, the learned counsel for the party of the petitioner, this court, the learned counsel appearing on behalf of the petitioner, submit that he would like to withdraw the instant petition and avail his remedies before the executing court. Taking into account the above, the instant petition stands dismissed on withdrawal. Full stop.
I thought the matter may pass after time in matter. Senior counsel pilot can to reject this case. Senior counsel pilot can to reject the time in matter.
What is this case about?
I thought this pilot, senior pilot is the finance pilot. And pilot, his tenant pilot, the order pilot. Pilot, one pilot, he pilot, operated pilot,
Which order? Order is?
this is pilot, order pilot 1711, pilot.
Which order are you challenging?
Page 84.
Page
84.
80?
84. And pilot page 91 of
84. Redressal, National Consumer Redressal Forum. Why are you challenging here? Why 227?
when pilot.
Huh.
Partial component.
This was done in 2023. Now, this was done when the Consumer Protection Act, now recent one, has come into being. Where is that act? 2019. On the auction.
Protect my password time.
Hmm.
Fair.
We'll have it after some time.
Right.
We'll have it at 2. 2, if Mr. Chaudhary does not appear, then your fate is with you.
Okay.
Take this book.
4.
Yes, what is this?
Pilot. Petitioner type 1 title for method for the pending before the number 1 method. And one amendment petition was filed and that was rejected.
amendment application rejected in 2016. We are in 2024. It is still going on. My goodness.
Supreme order is a case
And we blame the trial court of not disposing of suits early.
That in this case, my lord.
Who is the plaintiff?
And, they are the plaintiff, my lord.
They wanted the amendment.
They wanted to amend.
Amend at what stage?
evidence.
Evidence, plaintiff evidence or defendant's evidence? Plaintiff evidence. Yeah, has the evidence of the plaintiff been completed?
No,
What did you want to amend? Let's see your amended application.
amendment petition is at case 24. That the petitioner might by filing the title to state for declaration of right title and recovery of defendant by filing WS, my lord, stated that they have purchased the suit land. And by way of amendment, plaintiff prayed for, my lord, cancellation of that project. That is the
Now tell me why you, in your petition at paragraph number 2 of your application filed under order 6 rule 17, you categorically say that from the written statement you have come to learn about this thing. Then why you filed it only at the time of evidence?
yes, my lord, there is considerable delay, and
Yeah.
that is not
We
properly
reject it.
explained.
We can't give it to you.
But my lord, what happened, my lord, is it, my lord, necessary?
Huh?
It is necessary, my lord, for proper adjudication. And what happened, my lord, although it is not properly explained.
But
to
if
the-
you have not explained the delay, why?
Not properly explained.
Now,
Yes,
if I
have
give it
seen
to you, that means we make it useless. Order 6 rule 17.
My lord, the eighth paragraph 3, my lord.
Ah.
Paragraph 3,
Ah.
is 26, lord.
Yes. Where is paragraph 3?
Explanation is here, my lord.
Huh?
Page 26, my lord.
26. Yes.
That the plaintiff was not aware about the fact of alleged execution of sale deed for transfer dated transfer as well as the mediation granted in favor of Sitaram Setia. I thought that the transfer passed in transfer till the date of receipt of the written statement filed by the defendant. Being apprised about the said alleged execution of the sale deed for transfer dated and mutation granted in favor of Sitaram Setia by.
What is your suit for?
matter?
Suit for?
So for declaration of right title interest and recovery of possession of my lord 5.5 lakh.
Recovery of possession.
Right.
How much land? 5.5 lakhs. Huh?
Right.
What is the stage of the suit?
It evidence is my.
Huh?
But evidence.
Evidence means what evidence?
Evidence of PW.
Has the PW submitted his
No.
evidence? How do I know? Hmm? Yes. How do I know? Yes, Mr. Sansiti, what was the state?
My lord, yes, my lord. They have not filed their evidence.
They have not filed that.
They have not filed their evidence.
We allow that amendment,
my lord, the
but
suit-
subject to cost of 25,000.
Here, my lord, my one submission, my lord. Their claim is this, that after going through my detailed statement, they came to know about the. salary,
Understood,
which is-
Mr.
which is not
Sansiti,
correct,
I've
my lord.
understood
My
that.
lord, one minute,
Because
my
why I'm asking them, you see, I am not going, I'm also making it clear that the doctrine of relation back shall not apply. Meaning thereby, the amendment has to be construed from the date on which the amended plaint will be filed.
Correct, my lord.
So that will be then.
Yes.
Your basic question is, in 1978, they said that they came to learn about it. But one thing has to be done, because tomorrow again, another aspect will remain, that sale deed will remain as it is. He may again challenge. Unnecessary.
My lord,
Let it be
my lord,
done for one
my-
for all.
my lord, one submission, my lord. Before filing this suit, my lord, I have also filed a suit in the year 2011, TS number 67 of 2011, for declaration of right title and for preventing them not to encroach my land. There I have made the statement that I have purchased this land by the registered sale deal number so and so. In that case, they have appeared, but they did not file any written statement counterclaim that they are the owner and the sale deed is liable to be cancelled. My lord, may come at page 21, and I have also stated this fact in my written statement at page 21, my lord. At page 21, that is my written statement, paragraph 11, my lord, that the plaintiff has made a contradictory statement while filing of the present suit. The answering defendant instituted TS number 67 of 2011 against the plaintiff. The same is pending for disposal before the Land Court of Municipal for disposal. At the present plaintiff as defendant appeared in the above suit, filed a written statement in the month of September 2011, and nowhere he ever in his written statement that the present defendant debarred him from going to the land of the present plaintiff and denied his title over the land. Furthermore, no counterclaim for recovery of possession and any other relief has been claimed in that suit. So that was their stand taken by them. Now here they have taken.
No, that is not the subject matter which have been taken into consideration.
Regarding knowledge, my lord, I am submitting regarding knowledge, my lord. Now, moreover, my lord, they have taken one plea also in there. With
All these pleas will be available with you.
No, my
Mr. Sankiti, all these pleas as regards the limitation. You see, your basic question is limitation.
no, my limitation is not applicable, my lord. So my submission is so because under order 6 rule 17, the provision of limitation act is not applicable.
Huh?
Provision of the limitation act is not applicable.
Where?
Because under order 6 rule 17, because
I understand.
Yes,
In
my
your suit,
yes, my lord.
in your suit, the limitation will be a question of limitation as being your defense will be well protected.
Yes, my lord.
That is what I want.
Yeah, no, only one submission, my lord. Maybe, Lord, my lord. They have made a statement in their statement that the sale deed which is executed in the year 1978 is forced and fraudulent. So naturally, my lord, I shall produce my sale deed at the time of giving my evidence. They can question that sale deed and may also make a prayer before the court to send it to the handwriting expert whether the signature is forged or not. For that purpose, why they want a prayer for cancellation of sale deed? Because by that sale deed, my lord, I have purchased one plot of land that is purchased by me in the on 1905 and 1978, my lord.
Mr. Sankiti, kindly see your objection. Filed at page 27.
Yes, my lord. That
Have
was
you mentioned all these things?
my lord, that
Have
was
you mentioned all these things?
that was not well drafted. That was not well drafted, my lord. That was not well drafted, my lord.
Enough.
But-
You have not drafted.
But-
Drafted, I'm not concerned.
Before that, my lord,
Oh.
one WPC
Okay.
is also pending.
Okay, Mr. Sankiti, the more you argue, the less amount of cost. His cost is just coming down.
Only
Initially, I thought
my-
25,000, now it is becoming 15.
my
Any further argument, it will become 10. That is your risk and cost.
on WSC is also pending notice only will for
7,500.
I am not asking. WPC is pending notice only about it. Related to the sale land.
2,500.
WC is pending, my lord.
We can add now 2,500 in your
Okay.
favor.
My lord, it is up to your lordship, but my submission is, my lord.
Absolutely no.
I have to point out all the facts for this.
Anything you have to say, go to Supreme Court then.
My lord, it is-
Yes.
my-
This is an application under Article 227 of the Constitution, challenging the order dated 17/5/2016,
No.
passed in case number 18/2015, arising out of title suit number 13/2012, whereby the application filed under Order 6 Rule 17 of the Code of Civil Procedure 1908, read with section 151 of the said code, was rejected. From the materials on record, it reveals that the plaintiff, who are the petitioners herein, had filed a suit for declaration of right, title, and interest of the plaintiff over the Schedule A land, semicolon, for cast possession of the same, and also for permanent injunction. The said suit was registered as and numbered as title suit number 13/2012. The defendant thereupon filed a written statement on 11/4/2012, wherein it was categorically mentioned that the defendants are claiming right, title, and interest over the Schedule A land on the basis of a sale deed number 5050/78, dated 19/5/1978, executed by the predecessor, executed by one Dungarmal Bagaria in favor of Sitaram Sethia. Thereupon, the plaintiff do not take any steps. At the stage when the suit was fixed for filing of submission of the evidence on affidavit of the plaintiff, the application under Order 7 Rule 17, Order 6 Rule 17, read with Section 151 of the Code, was filed, thereby to amend the plaint that was filed, to seeking amendment of the plaint, thereby to insert paragraph 4A and 4B, and in addition to that, seeking the reliefs of a decree for cancellation of the said sale deed on the ground that the same is fraudulent, illegal, and null and void, and a precept be issued in that regard. Upon the said application being filed, the defendants had filed an application, had filed their objection, stating inter alia that the plaintiff knew very well about the deed of sale, as the same was duly mentioned in the written statement which was received by the counsel for the plaintiffs on 11/4/2012, and after a lapse of more than 3 years, have filed the said application. The learned trial court, by an order dated 17/5/2016, rejected the said application filed by the plaintiff, the petitioner, on the ground that there has been no satisfactory explanation to the delay in filing the application. That too, when the trial had started. It is against the said order the instant application has been filed before this court, challenging the order dated 17/5/2016. This court have heard the learned counsel appearing on behalf of the petitioner as well as the respondent. The learned counsel appearing on behalf of the petitioner, Mr. So-and-so, submitted that after the written statement was filed, the plaintiff made necessary inquiry, and as such, there has been a delay. He further submitted that only after that issues were framed, and thereupon, at the time when the evidence on affidavit was required to be filed, the plaintiff had sought the application, sought amendment of the plaint. On the other hand, Mr. R.C. Santati, the learned counsel appearing on behalf of the respondent, submit that there has been a clear-cut case of negligence on the part of the petitioner's plaintiff in filing the application seeking amendment. He further submitted that the plaintiff very well knew, since even very well knew about the execution of the deed of sale even prior to the filing of the suit. However, it has been however, in order to mislead the trial court as well as this court, the plaintiffs have stated that they only came to know about the filing of the execution of the deed of sale only after filing of the written statement. He further submitted that if the amendment is allowed, it would impact the defense of limitation, which the plaintiff, which the defendant has a right on the has a due right as per the statute. This court, upon hearing, having given the anxious consideration to the relevant submissions, this court is of the opinion that the question of limitation as to whether the amendment sought for, the question of limitation as regards the this court, having given the anxious consideration, this court is of the opinion that the issue of limitation, or for that matter, as to whether any challenge would be barred by limitation, cannot be decided in at the stage of a proceedings under Order 6 Rule 17. This court, however, is aware of the fact that the provisions of the Limitation Act 1963 confers a statutory right upon the respondents, upon the defendants. And in the instant case, it has been the specific case of the defendants that the petitioners of the plaintiffs knew about the deed of sale even prior to the filing of the suit. Under such circumstances, this court is also aware of the fact that the entire suit of the plaintiff would become nugatory if the amendment is not allowed, taking into account that the right which the plaintiffs are claiming for declaration in their of the Schedule A land in their favor and for recovery of past possession cannot be adjudicated if cannot lead to a valid adjudication unless and until the sale deed is put to challenge. So, under such circumstances, the decision as regards whether the sale deed was whether there was any valid sale deed in favor of the defendant touches on the question of real adjudication of the real dispute in controversy. In the backdrop of the above, let this court now take into account that there has been a delay, take into account the aspect as regards a delay in filing the application seeking amendment. No doubt, the trial had started in view of the filing of the in view of the date fixed for filing of the evidence on affidavit. But taking into account that the real dispute in controversy is required to be adjudicated, this court is of the opinion that the amendment so sought for is required to be allowed. However, this court makes it very clear that while allowing the said amendment, the principle of rejection back shall not apply, meaning thereby the amendments which have been allowed shall be treated to have been allowed only from the date of the instant order. No, from the date of filing of the amended claim, which this court directs the applicant from the date of the instant order. This court is also aware of the fact that the suit had progressed substantially for a period of 3 years after the filing of the written statement, and the plaintiffs had delayed the suit. Under such circumstances, this court is of the opinion that some reasonable cost has to be imposed. Accordingly, this court allows the application, being Ms. case number 18/2015, passed in arising out of title suit number 13/2012, thereby permitting the amendments which have been sought for to insert paragraph 4A and 4B, as well as the relief C1 and C2 as detailed out in the amendment application, subject to a cost of deposit of rupees 25,000 by the plaintiffs before the trial court. This court fixes the matter on today's what date? First, on 19th of April 2024 before the trial court. And on that very date, the petitioner plaintiff would have to file their amended claim without faith, amended claim, and also deposit the cost of rupees 25,000, which shall be a condition precedent for acceptance of the amended claim. This court further observed that in failure to do so, the consequences under Order 6, Rule 18 shall duly come into play. With the above, the instant proceedings stand clear, the interim order passed earlier stands vacated, and the trial court shall proceed with the suit in accordance.
My lord, time period may take at the filing of my lord amendment petition.
Huh?
From the date of filing of amendment petition, it should be effected, my lord.
What?
Time period, my lord, that limitation.
For what?
So far, my lord, I have heard, my lord, it is effected from the date of filing of amended petition. But limitation, my lord, that is applicable at the time of my lord, filing of amendment petition. Because it was filed in the year 2015, now it is 2020. And amended petition will file the next date, my lord, date by date.
Mr. Counsel, that submission should be made by Mr. Sancity. I am giving you a favor of 7 or 10 days in your favor. Then
It is allowed in.
I have said that the doctrine of relation back shall not apply. Doctrine of relation back means when an amendment is allowed, it dates back to the date of the suit. I say that the doctrine of relation back shall not apply. It shall only apply with effect from the date of the instant order. That means from today. Now, so your amendment will be done as of, to be construed only from today. Now you want the amendment to be taken after for some more days, which means it is, he has to say submit.
They have actually challenged an order by way of which, my lord, their plaintiff's evidence was closed and the matter was fixed for DW's. That order they have challenged.
How many days they have taken?
My lord, 10 occasions, my lord, they have paid.
Huh?
10 occasions, my lord. Once, my lord, cost was imposed, my lord. That was 600, my lord. They failed to deposit the cost. Then again, 400 further cost was imposed. They still failed. They took adjournment, my lord. Then subsequently, my lord, by order dated 11/5/2022, their prayer was rejected, my lord. Further adjournment was rejected and the matter was fixed for DWs. Then they again filed a petition, my lord, on medical grounds. And when the court asked them to produce the medical proof, my lord, they again took adjournment, my lord. And accordingly, my lord, on 21/9/2022, their petition was rejected and the matter was fixed for DWs, my lord.
This is an application under Article 57 of the Constitution challenging the order dated 21/9/2022 passed by the learned court of the Municip number 2 Dhubri, entitled suit number 148 of 2015. By the same impugned order, the learned trial court have rejected the application filed by the plaintiff for permitting the plaintiff to adduce evidence and fixed 29/10/2022 for DW. From the materials on record, it reveals that the plaintiffs have already taken 10 adjournments
10 adjournment, my lord. Well, I have filed affidavit, my lord.
and after the 10 adjournments have been granted, then also the plaintiff did not file the evidence on application. This court duly takes note of the provisions of Order 17, Rule 1, wherein it stipulates that not more than 3 adjournments has to be granted, there can be granted. In the instant case, not the learned trial court have been was much lenient in granting more than what was envisaged even under the statutory regime. Under such circumstances, this court finds no jurisdictional error in the order dated 21/9/2022, passed entitled suit number 148 of 2015. Accordingly, the instant petition therefore stands dismissed. The order dated 22/12/2022, passed by this court, stands vacated, and the trial court shall proceed with the adjudication of title suit number 148 of 2015 in accordance.
My lord, date for appearance before the trial court.
Huh?
Date for appearance before the trial court, my lord.
The trial court shall proceed with the adjudication of title suit number 148 of 2015 on the basis of a certified copy being placed before the trial court. The certified copy of the instant order be placed before the trial court. This court further fixes with 2nd of April, on which date the party shall appear before the trial.
Highly obliged.
Item 6.
Yes,
Yes, I had challenged the order by which the plaintiff witness PW was allowed to be taken
Huh?
into consideration. If an order, Lordship, which allows the PW to be taken as a witness, he is not a listed witness.
13/12.
Yes, Lord. Annexed 8, page 38.
So that was allowed.
Yes, but
So
PWC. My only objection is that he is a retired revenue officer. So Lordship, after not I put was translated back to decide after take knew it. Thereafter they filed an application to execute the PW2. That was allowed. That was also the witness have also. That was allowed. And thereafter the PW tried and now want to educe the PW3. I have objected is a retired government from revenue department. Is not with the case.
so you asked him at the time of cross that you have no business out there. See, you are on the credentials of the witness. Credentials of the witness can be appreciated when the evidence is adduced. How is this court going to do all these things?
They are one after one and a witness.
They won't give any if this matter is further delayed out there, this PW3 will also die. This is an application under Article 227 of the Constitution challenging the order dated 13/12/2022, passed in title suit number 97 of the 2001, whereby the learned trial court, that is the court of the Munsif number 1, Dhubri, had permitted adducing of witness of PW3 in title suit number 97 of the 2001 on the ground that the PW2 who had submitted his evidence on affidavit expired prior to his cross-examination. This court, having perused the order dated 13/12/2022, is of the opinion that the said order does not suffer from any jurisdictional error, and more so, the question of interfering with the said order in exercise of the powers under Article 227 of the Constitution does not arise. Accordingly, the instant petition therefore stands dismissed. The order dated 5/6/2023 passed by this court is vacated. The trial court, as both the parties are duly represented, the parties are directed to duly represented, so they are directed to appear before the trial court on 2nd of May 2024. So the trial court shall proceed with the disposal of title suit number 97/2001 in accordance with law.
Publish.
7.
Yes, what is your case?
Well, here I'm challenging the order whereby an amendment has been allowed. So the
Amendment application was allowed.
allowed. Well, before I start with the case, I've been newly engaged. I found one difficulty in the petition, one difficulty in the petition, that this application, this revision petition has been filed under section 115.
Don't worry.
Well,
Don't worry.
I'll-
Don't worry with all this.
Well,
These are simple aspects. Now
Well,
tell me, what
your
is
lordship will find the application praying for amendment at page 40, man.
Yes.
I'll take your lordship to page 41. These are the amendments. Page 41, paragraph 5. May I just read? The plaintiff hereby pays for substituting the paragraph 6 of the plaint by inserting the following amendment paragraph in the body of the plaint. That the right title interest of the plaintiff and the pro forma defendant in respect of the suit land has been clouded as a result of illegal mutation insertion of the names of the defendants, their father in the record of right without having any document of right. The plaintiff and the pro forma defendant requested the defendant several times to vacate the suit land and to hand over the class possession. But the defendant turned a deaf ear to the repeated request of the plaintiff and the pro forma and also refused to give the share of paddy crop, so that the plaintiff is entitled to recover the possession of the suit land by evicting the defendant therefrom, holding the defendant as the trespasser to the suit. It is respectfully submitted that the mutation of the names of the defendant in revenue record neither create any right title and interest in favor of nor extinguish the right title interest of the plaintiff and pro forma defendants over the ancestral land, specifically described in schedule of the state. It is further submitted that the fraudulent illegal mutation orders surreptitiously made cannot confer any right title interest in favor of the defendant with regard to the second amendment sought for in paragraph 10, where they have now claimed the mean profit of 2,50,000 that is due since 2012. And paragraph 13, the cost title of the article is thought to be amended, and two new prayer melodies, para 8 of page 43, recovery of first position and recovery of the mean profit of 2,50,000. Now, the originally the suit in the plaint, my lord will find case 11 is the plaint.
You have filed a written statement, amended claim.
Yes.
Filed. What is the stage of the suit?
My lord, immediately after, my lord, issue has not yet been.
There was a stay.
Stay.
Basically, my lord, in my submission, my lord, the para 6, para 10, and the new prayer of recovery, my lord, this is time part. Because admittedly, my lord, in the plaint they have claimed that it was due since 2012. As per Article 52 of the Limitation Act.
So let the trial court decide that.
That there is a judgment of the Honorable Apex Court, which says, my lord, if the amendment which has been sought for, my lord, if it is time barred, that should not be here.
There are many judgments thereafter which goes against.
1957 thereafter relied on 2008.
Was it?
And the recovery of first position, my lord, the prayer, this was already a pleading in when this suit was filed. That we were in possession.
Is not there.
It is there. Para 6, my lord, of the plaint at page 60. What they projected it, my lord, that till 2017 we were cultivating, but since 2017 we are not cultivating, and therefore they have not prayed for the prayer for recovery of it.
Because, my lord, at that time, my lord, land was vacant.
But that again is a contradicted, my lord, if your lordship will allow me to read para 6 of the plaint.
Read it.
They say that they have.
They say that you were cultivating till 2018. Thereafter, you left it, and
But-
as such, they have not sought for recovery of past possession. However, if later on it comes to light, then they will seek for.
But-
Whereas in your written statement, you have specifically stated that you
That
have been
we are-
cultivating from your father's time. Therefore, they are.
And at the same time in para 6, they say that they have demanded for recovery of the possession.
They have not. They
Yes,
will.
yes, my lord. The fourth line, my lord, the
Hmm.
plaintiff and the profound defendant requested the defendant several times to vacate the suit land and to hand over the khas possession.
Hmm.
But the defendants turned a deaf ear to the repeated request of the plaintiff and the pro forma defendant, and also refused to give share of the petty till the year 2007.
Then the next line.
Then it may be mentioned here that the
It
defendant
may,
ceased to
however,
cultivate-
however,
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 it may,
has a very-
however, be mentioned here that the defendant ceased to cultivate the suit land from the year 2018 onward, but the plaintiff has no reason to pray for now recovery of first possession of the suit land. It is only because we were not cultivating, that is what they projected. But in the second paragraph, they say that they have been demanding for first possession, which means that my possession has never been denied by them.
And are the plaintiff not claiming right title and interest over the land?
They are
Yes,
claiming.
yes.
If they are claiming right title interest, meaning thereby they say that they have right over the land, and anybody in occupation out there, obviously right of recovery of possession is required. But if nobody is done, then on the basis of the law laid down by the Supreme Court, it goes back to the owner of the land. If it is the land is vacant.
No, here projection in the suit is that I am a tenant.
They have denied.
and we have denied.
Very well. We don't see any ground for interference. Anyway, it is an application under Article 227 of the Constitution, application under Section 115 of the Code of Civil 1908 for challenging the order dated 21/2023 passed in title suit number 05/2022, whereby the petition application seeking amendment of the plaint under Order 6 Rule 17 of the Code was allowed. This court have duly taken note of that the instant proceedings ought to have been proceedings under Article 227 of the Constitution and not an application under Section 115 of the Code. And as such, for the interest of justice, the state proceeding, the instant proceedings is converted to a proceedings under Article 227 of the Constitution. This court have duly taken note of the application which was filed seeking amendment of the plaint and the grounds and reason stated therein. What is the state of the suit?
Issue has not yet framed.
It has also been brought to the notice of this court that till date, no issues brought to the notice of this court that prior to filing of the application under Order 6 Rule 17 of the Code seeking amendment of the plaint, no issues were framed. The court have also taken note of paragraph number 6 of the plaint and the reasons were assigned as to why now it has become necessary for the purpose of seeking the relief for seeking the amendment of the plaint as well as also the amendment to the reliefs sought for in the plaint. This court have also taken note of the order dated 21/2023 passed by the trial court and is of the opinion that the state order do not suffer from any jurisdictional error. Moreover, the question of interference of this order, of the impugn order dated 21/2023 is not called for in a proceeding under Article 227 of the Constitution in the present facts. Accordingly, the instant petition therefore stands dismissed. The interim order dated 10/5/2023 stands vacated and the parties being duly represented are directed to appear before the trial court on 2nd of May 2024. The Court of the Munsif number 1, Golaghat, shall proceed with title suit number 05/2020 in accordance.
The liberty to file an additional case.
What you will obviously get. Why should I give you liberty?
But as I've been told, my lord, it was fixed for issue. After the amended plaint, it was fixed for issue.
Well, they have taken time for filing the additional written statement also. But then the court has granted them time. But then this petition was filed and the matter was paid. So, my lord, they can very well file.
Mr. Before concluding, this court, however, observes that the plaintiff, the defendant herein, would be at liberty to file their written statement on the next date so fixed without it.
Great.
Obliged.
1 month enough. Yes, what is this?
Made this about. This petition is directed against the impugn order, your lordship, granting interim maintenance to be paid by the petitioner, who is the husband, the respondent is the wife, your lordship. The application was decided very casually, your lordship. In fact, the guidelines issued by the Honorable Apex Court.
Who is the maintenance? You are the husband?
I'm the husband.
Why?
No, wife.
How much it has been granted?
5,500.
5,000. And you were, what do you do?
I do a contractual employee in a bank, sanitation worker, manual labor.
How much is your income?
He's getting about 14,000 rupees.
14,000. And with the wife, how many, is the wife residing alone? Or
She's
they-
residing with her parents, your lordship.
She has no income of her own.
That is what I have denied in the in my WS. The court. Both of us are doing manual work, your lordship. We belong to
Hmm?
both of us. I am also doing manual work. She also does manual work, and she's also earning something.
She's also.
Not correct. Let's say we come to page 20.
Now, the marriage took place in 1990, lordship. For 7 months they were together, but the marriage has not been consummated. This is an admitted position. The petitioner claims that it is the wife who has not allowed consummation of marriage, while the wife claims that she is important, for which the marriage could not be consummated. Ultimately, she filed a divorce petition to which I have filed my WS. And then this proceeding under section 24 was filed for interim maintenance. But people get this application at page number 28 very casually without giving any details, your lordship.
Yes, you are referring to
The application at page number 28.
whose petition?
They are claiming maintenance. But it's a very casual application, your lordship, only to that on account of the harassment and cruelty caused by the respondent husband, and on account of being ousted from her matrimonial home, the petitioner is residing in her parental house about 111,000.
Oh, how much you are earning?
14,000 rupees.
Huh?
14,000.
14.
Yes.
So you must be having a salary slip or something.
If I have the bank account statement. Bank account statement.
Where is it?
It's not there, but I have
Why haven't you enclosed here?
I have corrected.
Huh? To me.
He can produce his pay slip also. That he can place his pay slip. And our as per the statement of the wife, his salary is 40,000, and besides that he has permanent landed property in Guwahati.
Initially, he was getting 13,000, but the period is increased every month. It is a contractual employee of the station purpose. His aging parents to look after his younger brother for apart from day-to-day life affairs. The marriage was not consummated 7 months.
Why the income is fluctuating?
Initially, it was 13,000, but after about 6 months, they get some.
No, now it is 15,308.
Yes, yes, that is the last.
Now it has again increased to 15,606.
It is on the basis of there some daily calculation is done on how many days you have got something, maybe like that.
Hmm?
How many days he has got? It is a contractual employee.
So what is wrong? in giving 5,500?
Lordship knows that the decision rendered by the apex court in Ratnesh, but Neha, which prescribes that in deciding any maintenance state, be it interim maintenance or permanent maintenance, assets and liabilities have to be submitted by both the parties, so that the court can choose a
Did you
pragmatic
submit?
method. Both of us will appear and will.
Did you submit?
I did not submit, even Sales has not submitted.
So?
Yet.
When was the application filed?
I have filed my WSA lordship in that case.
No. Where is the application filed?
22nd June
Application was filed when?
26 June 2023.
22nd.
Where is the
Page
application?
28.
Page
Our
28.
application, Your
Application was filed on 22/6/2023.
Lordship.
Then why didn't you submit?
No, I have filed a WSA lordship. Or written objection.
Okay, can you raise that point if you don't submit your assets and liability?
Even she has also not submitted.
Forget about her. You that very well could have said, then look here, I have not.
But this is a mandatory requirement, Your Lordship. Most of the case courts below are not.
Understood. The court have duly taken note of that. None of the parties have done so.
Just take the judgment of our concourse. Let both the parties file their assets and liabilities, and that the court decide the matter here. Because what he has stated, I have denied. That matters. If Your Lordship comes to impugned judgment at page number 34, I just.
And what does your brothers do?
They are still unemployed, Your Lordship. That is what I have.
What is their age?
All come if we submit.
Huh?
This all will come if we submit assets and liabilities. I took it. That's right.
You got to stay?
No,
No.
You're paying?
No, not paying. Till since the day of our interim order,
not
order.
pay there is.
Since 17/2023 order was passed, and not a single price has been paid.
No stay.
No.
Hello. Let the trial court put you behind the bars. This is where the trial court, you wanted to file your objection, the trial court did not give it. Here you filed your objection. You have never raised the issue that you are not going to file that application.
So whatever
The trial court have rightly taken it 5,000 rupees to be given 5,500.
5,500 plus 500 the litigation cost of 6,000.
500 is too less. It should be increased.
But it's also having income, Your Lordship, and secondly, Your Lordship, the fact that the petitioner has to look after his parents, that matter has also not been considered. Lordship will kindly see this order.
No, you have made a vague statement that you have to look after the parents.
In
What is the age of your parents?
Father is above 20, Your Lordship, mother above.
You are looking after her. How do we know? That is a usual statement which is being made. Did you look after her earlier? Prior to all this dispute? How much money did you give it to your parents earlier? Prior to this?
They are staying with the petitioner type.
Understood. So,
Staying with the petitioner. This marriage, only for 7 months they lived together. Marriage was not consummated. She filed a report on the ground of importance, and I am contesting the case, saying that it is she, because of her instance, the marriage could not be consummated. She does not want to live with me. Even I have filed a legal notice for restriction of conjugal rights. She has not come back a lot.
so you have got good amount of money for giving a legal notice. Also.
So I have tried my best so that he can come and we can have a family life, but he is not coming, Your Lordship. Now he has filed a divorce petition. I have contested the case. Now, Your Lordship, if takes up this business versus Neha, Your Lordship, the court has specifically directed that even for interim maintenance, assets and liabilities, especially those who is.
But you
paying-
never raised that. Did you submit?
No, I have also not.
You,
submitted.
you if you don't submit,
What happens, Your Lordship?
yeah, no, if you don't submit, can you raise that issue here? Tell me. Better, why don't you file a review on this aspect? File a review. Then look here, you have not, assets and liabilities have not been taken into consideration. So, better, because how can this court on 227 look into that?
Because this Rajneesh but Neha, when it has not been followed, the honorable apex court again in the case of Aditi versus Niti, that has been taken care of in this order, Your Lordship. It has again said that it is a mandatory requirement. It is found that most of the trial courts are not following. Even they are not asking the parties to file assets and disclosure liabilities, Your Lordship.
So take up that issue there.
And considering this aspect, Your Lordship, this honorable court direct, we both will go, Your Lordship, will submit our assets and liabilities, and that the court take a decision.
Both,
Your
forget about both. Both. First, you try yours. Without trying yours, you don't give it by yourself. Can you raise that issue? Let me do one thing. Let me dismiss it on that ground. That you have not given yours so that you can't raise that issue. Get it clarified for the better.
So whether this judgment has not percolated the trial court level, most of the cases I have
Understood.
Your Lordship.
I would have understood that if you submit your,
That
then you say
Yes.
that yes, I have done without considering her assets and liabilities he has done.
that is supposed to have come in the written objection.
Not a single word in your written objection. And see, the trial court have page 38. None of the parties have furnished the affidavit of assets and liabilities. Then how can you raise all these issues here? No. This is an application filed under section Article 227 of the Constitution, challenging the order dated 7/10/2023, passed in petition number 541 of 2023 in TSM 32 of 2023, whereby the learned trial court, by the impugned order, directed the petitioner herein, who was the opposite party in the said proceeding, to pay an amount of rupees 5,500 per month as maintenance pendant life, and additionally rupees 500 as litigation expenses per month to the respondent herein, who was the petitioner in those proceedings. The learned counsel, appearing on behalf of the petitioner, Mr. So-and-so, submitted that it is a well-settled principle of law as has been held by the Supreme Court in the case of Rajesh versus Neha and others, reported in 2021 2 SCC 324, that the court below, that the court, while adjudicating maintenance proceeding, has to obtain affidavit disclosing the assets and liabilities of both parties before passing an order. The learned counsel further referred to the judgment of the Supreme Court in the case of Aditi Elias Diti versus Jitesh Sharma, reported in 2023 SCC Online SC 51, wherein the principles as laid down in the case of Rajneesh Supra have been followed. This court, upon hearing the learned counsel, had put a specific query upon the learned, upon hearing the learned counsel for the petition, had put a specific query as to whether the petitioner, who had not submitted, who admitted they have not submitted the affidavit of assets, disclosing the assets and liability, and raise such a plea in a proceeding under Article 227 of the Constitution. More so, when the learned trial court, while passing the impugned order, have categorically also observed that none of the parties had furnished the affidavit of assets and liabilities. The learned counsel submitted with tender that the petitioner herein did not submit the affidavit of assets and liabilities. So taking into account the above, this court, without interfering with the order dated 7/10/2023, grants the liberty to the petitioner to file a review application before the trial court on the basis of in the lines of the law laid down by the Supreme Court in the case of Rajneesh Supra and Aditi. Rajneesh Supra and Aditi, alias Miti Supra. Also, it is made clear that if such application is filed, the petitioner has to submit the file. Such application can only be entertained if the petitioner duly submits, the petitioner of hearing will duly submit the affidavit of assets and liabilities. The learned trial court, that is the court of the additional district judge Jorhat, shall then consider such application if filed within 30 days from today. With the above, the instant proceedings stands disposed of.
Much like
Right.
Petition Lordship.
Mm.
In this
What
case,
is this?
amendment plaint is allowed.
So,
Right, the order dated 57/2020, page 54. In this case, the amendment petition actually filed on 2016. It is order amendment petition filed on 2016, but in this order reflected that amendment petition filed 2016, but last line in this order, page 56, with the case number 149 of 2020 is accordingly allowed.
Huh?
There is system.
case number 1 is allowed, accordingly allowed in court. Yes, tell me, what is wrong?
That the text of this case is accordingly to the respondent. Plaintiff is that the land mentioned in Schedule 1 or
No. Why are you saying what is wrong? You see, a suit was filed. And then a plaint, an order 6 rule 17 was filed in the year 2023.
23.
And that was registered as miss case number 149 of 2023.
Right.
Then it was allowed.
Allowed, and in this order, page 54, petitioner side file petition right number 83 of 2016. Under order 6 Rule 17 dated with the section 151 of CPC, saying for amendment of the plaint. Other side receive copy and so and so. And last line, finally say page 56. Midday case number 149 of 2020 is accordingly allowed at disposal of
So-
court. Actually, amendment petition was filed on 2016.
No. It was filed on 10/4/2023. Finally, see Annexure C.
My lord, in this order reflected,
Forget about the order. That might have been given some number, because if you see, it is
Only the
filed on
number.
10/4/2023.
It is only the number, my lord, not
Number
yes.
10/4/2023.
proposed amendment of the plaint is allowed for bringing some new facts of for the
Mr. Counsel,
my lord.
filed on 10/4/2023. So, what is wrong with the order?
Order is correct, my lord.
Huh?
Order is correct.
Then withdraw.
Some original
Have you filed your
nature
Yes,
and character of
we
the
filed,
original
my lord.
suit.
Amended.
amended plain file?
Yes.
Have you filed your amended written statement?
No, my lord.
Okay. There's a stay, we vacate the stay. You file your amended written statement by 2nd of May. Okay?
In the stage of evidence stage, cross-examination stage, this petition is
File at the time of cross-examination.
my lord.
What is the amendment?
Cancellation of partition deed number 851843 dated 12/4/2006, confirmation of possession and for permanent injunction, and therefore to change the schedule of the land to bring on record sale deed without mentioning how the sale deed would affect in the prayer made in the land cannot be treated to be justified and permissibility. Proposed amendment apparently going to the change the nature and character of the original title.
Now, kindly see this paragraph, page 55. The last 4 lines. Yes, Mr. Counsel.
Yes.
Kindly come down. Last 4 lines of page 55. Under Order 6 Rule 17, court may at any stage of the proceedings allow either party to amend his pleading when such amendments are necessary for the purpose of determining the real question in controversy between the parties.
Yes.
The genuineness of the allegations made by the petitioner can be adjudicated only in the trial. If the fact intended to be brought in the case record, if allowed, may be helpful in the proper.
Correct.
In the instant case, trial has not commenced. Hence, if the plaint is allowed to be amended, it will not cause any prejudice to the other side. That's wrong.
Trial has commenced. Trial has commenced. my lord.
Then?
But at any stage, my lord, amendment can be taken.
No.
Now it is processed by the defense.
We can't allow this thing like this to happen. What was the stage of the suit?
Uh, now it is processed by the defendant. Defense evidence.
Huh?
At the defense evidence.
Now?
Yes.
After amendment?
After amendment, not man. Prior to at the time of amendment.
It was at
On-
the stage of?
Defense evidence.
After plaintiff evidence is over, this was allowed.
Yes.
And now it has now gone back to the stage of the trial court. The pleading.
Pleading.
We have to interpret. Absolutely courageous. This is an application under Article 227 of the Constitution challenging the order dated 15/7/2023, passed in Music case number 149 of the 2023 arising out of title suit number 114 of the 2016. Whereby the application under Order 6 Rule 17 of the Code of Civil Procedure 1908 for short the court was allowed by the learned trial court. From the materials on record, it reveals that a suit was filed by the plaintiff seeking declaration and for permanent injunction. The said suit was registered and numbered as title suit number 114 of 2016. After the suit was filed, there were various the defendants had filed their written statement. Thereupon, issues were framed. The plaintiff's evidence was duly completed. And when the suit was at the stage of defendant's evidence, an application was filed under Order 6 Rule 17 seeking amendment of the plaint This application was registered and numbered as Mise case number 149 of 2023. The respondent, the defendants, duly filed their written objection. Stating inter alia that the said amendment so prayed for ought to be rejected on the ground that mere engagement of a new advocate cannot be a ground for any amendment, that too at the belated stage. It was also categorically mentioned in paragraph number 2 of the written objection that the plaintiff side have already submitted the evidence, and acceptance of the amendment at this stage will emanate a de novo trial which would not be reasonable under any respect. It is also seen that from the said written objection that the defendants have also raised the issue that if the said amendments are allowed, it to change the nature and character of the suit. This court, in the backdrop of the above, if this court takes note of the order dated 15/7/2023 passed by the learned trial court, it shocks and surprises this court to take note of that even when the evidence of the plaintiff was over and the suit was fixed at the stage of defendant's evidence, the trial court, in a complete misconceived notion as regards commencement of trial, had held that the trial had not commenced. The learned trial court had also not taken into consideration the amendment brought to the provisions of Order 6, Rule 17 by the amendments carried out in the year 2002, which makes it mandatory on the part of the learned trial court, while allowing the amendment of the plaint, that the trial court has to come to a conclusion that in spite of diligence, the party could not have raised the matter before the commencement of trial. There is no finding to that effect. Further to that, this court, having perused the application filed by the plaintiffs under Order 6, Rule 17, also finds no good reasons assigned to the aspect that due diligence was exercised by the plaintiffs. Considering the above, this court is of the opinion that the impugned order dated 15/7/2023 is a result of complete non-application of mind of the learned trial court. Apart from the same being completely is also, apart from the said, being contrary to the proviso to Order 6, Rule 17 of the Code. Accordingly, the impugned order dated 15/7/2023 is set aside and quashed. The amended plaint which have been filed pursuant to the order dated 15/7/2023 has to be therefore disregarded, and the trial court shall proceed with the disposal of the suit on the basis of the plaint which existed at the time of filing of the suit. With the above, the instant petition stands allowed with cost.
Amendment petition 2020.
2023 only, I think.
119.
Huh? No. What did I say?
Amendment.
19. I never said that.
CPC amended 2000.
I said CPC 17/2002.
Okay.
Before concluding, this court makes it clear that the order dated 1/9/2023 stands vacated, and the parties are directed to appear before the trial court on 2nd of May 2024, on which date the trial court shall fix a date for the evidence of the defendants.
Okay.
Fix a date for further proceedings of the suit in accordance.
Obliged.
Yes.
May I read the lordship? The LA appeal lordship.
Okay, we admit the appeal.
Yes, sir. Transportation warrant stamp lordship along with LA appeal number 14 of this.
Why?
Because already what is the same appeal lordship, respondent is same lordship, petitioner is different. Same.
I to order.
My lord, one thing I have to say, my lord, is in the original code below, the original code while dismissing the reference case, it pointed out that a necessary party has not been impleted. And now they have done the same mistake, and last time they have filed a civil procedure, civil revision petition, and that had to be withdrawn. Now they have filed appeal. So in that petition also the same mistake was there. And it was pointed out. Now they are again making that same mistake. They have not made the Inland Water Authority of India party. They are the people for which we had acquired the land. And they are the people who are going to pay the money. And they are asking for enhancement. How are we to know whether they will be in a position to pay or not? And my lord, it was there is a constitutional case. It was pointed out in the by the reference code also, and it was specifically referred to in the order. And may I read it out, ma'am?
Not necessary. You are referring to the 95 judgment?
Yes, 95, and then it was said that the party on whose behalf
This is on the
necessary
basis.
and
This is on the basis of Section 20 of the Land Acquisition Act
Yes, yes.
1894, wherein it says it is not required to make the requiring authority a party. However, in 95 Supreme Court, the Supreme Court said that then also, as these people are going to make the payment, as such they are required.
Yeah.
It's okay.
So, my lord, it can be implemented so that the defect is removed, my lord. And then,
If we implead them, allow them to implead
Yes.
now,
yeah.
what will happen to that proceedings? Shouldn't we raise this? Shouldn't you raise this point
In the
on
lower
the
court, yes, yes.
no, when the appeal is admitted and thereupon one fine day you raise these points, we dismiss all his appeals, long appeals.
Yeah. But they are asking for enhancement, my lord. And the Inland Water Authority is
Understood,
going to pay the
Mr.
money.
Botchaji. Everything is understood. So let us make you, we admit the appeal. Let us see what will happen later on.
Yes. On the next date, my lord, we will be going on a remand, my on the point of remand, if it is possible to remand it.
Why?
To allow them to implement the Inland Water Authority.
You want to make them get, or are you in favor of the appellants?
So then my lord is favorably disposed. That is another thing.
No,
I'm just
the
raising
thing is
the
like
point that is
this.
all.
They should, in fact, cause
Okay, for
raise
today,
that
my
issue.
lord, allow the admit the case.
Admit order to the report. Order. Admit the appeal for the record. Line fee. So खाली date kita number kita set. या तो ये बच्चे itu तो I think hero ya ये बच्चे
My lord is calling for the record.
Huh?
Then it will be good for.
Please, the lordship.
Hmm.
My apologies for the lapses, lordship. But if lordship permits me 7 days time, I'll take the steps of the response.
Yes, tell me, what is your case?
My lord, so this is against an erroneous order passed by the learned trial court. I mean, 2 petitions were filed for impleadment of defendant. One filed by the plaintiff petitioner and another by the defendants who prayed for being impleaded as party respondent defendants in the suit, against which, my lord, the petitioner plaintiff filed his objection. That because they merely happened to, their claim is that they had executed certain agreements with the
the legal heirs of the deceased patadar of the land. Therefore, they should be impleaded as party defendants in this. So against that, we filed our objection, my lord. Kindly come to their application, page 21 of my petition. This petition is by one Haider Ali and number 2 Abdul Noor. Their contention, my lord, is that page 22, paragraph 4, they have stated why they want to be party defendants in this suit. That all the legal heirs and successors of late Golendra Momin have told the petitioner that they also deny the fact that the suit land of this suit has been sold to the plaintiff. The said legal heirs and successors have also denied about any arrangement agreement dated 18/2/2009 entered into between the plaintiff number 1 and late Golendra Momin. In fact, the said legal heirs and successors have also claimed title over the suit, and on the basis of said title, 2 of the legal heirs of late Golendra Momin, namely Labaino Sangma and Ella Binston Sangma, have entered into 2 agreements for sale with the petitioners, bearing number 6171 of 17 dated 24/6/17 and deed number 6172 of 17 dated 24/6/17 for sale of a part of this suit land measuring 4 katta in total. Now, on the basis of these 2 agreements, they filed this application for being impleaded as defendants in this suit. Against which, my lord, the plaintiff petitioner, we filed our objection, stating that since the impleaded defendants are actually the legal heirs of the deceased common ancestor, therefore they are not to be considered to be necessary and proper parties in this suit. And Lordship, at the same time, by Annexure 4 at page 31, the petitioner plaintiff also filed an application under Order 1, Rule 10, Sub-Rule 2, for adding some of the legal heirs of the deceased owner of the land as party defendant.
Sir, kindly come to paragraph number
Yes, my lord.
14 of your plaint. Page
Yes.
16 of
Paragraph 14, Lordship.
your plaint.
Yes, ma'am.
Plaintiff submits the Sita
That the
mutation.
Sita mutation granted in favor of plaintiff number 1 over the scheduled land as per the order of the then Assistant Settlement Officer Guwahati was cancelled upon the complaint of late Golendra Momin, that is the father of the defendant. Thereafter, the parties arrived at a compromise and amicably settled their differences by executing deed of agreement dated 18/2/2009 before the notary at Guwahati. The compromise induced the plaintiff number 1 to withdraw the cases filed by it. Consequently, the mutation of the plaintiff number 1 was restored in the land records by the Circle Officer, Dispute Revenue Circle, by it order dated 9/2/2011, passed in mutation case number 1397/2010-11, and order dated 5/2/2012, passed in partition case number 16.
Now kindly come to paragraph 15.
Yes,
The defendant, being the daughter of Golendra Momin, is bound by the terms of compromise between the plaintiff and Golendra by the agreement dated so and so. Okay. Now kindly come to page 18.
yes,
Order that the deed of agreement dated, I think it should be 18/2/2009.
yes, Lord.
Executed before the notary between the plaintiff and Golendra is binding upon the defendant.
Yes.
Okay. Now kindly come to page 22.
Yes.
What you have done, you have made only one.
Lordship, may I submit, my lord? Initially, what happened? This is the second round of litigation. The land was purchased by the
You are asking for a declaration.
Lordship.
only on the ground that there's other people.
No, we have, that is why, Lordship, we have prayed for impleading these, some of the other legal heirs which we subsequently came to know about as defendants in the suit. There is a miscase by us also, and the learned trial court passed a similar order in both the
No,
miscases.
are you aggrieved by the allowing annexure 2? Annexure 2 is whose petition?
No, I am aggrieved, Lordship, by the order dated 29/2/2020, which is at Annexure 5, page 37. Kindly.
No, 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 no. I understood.
Yes,
Are you aggrieved by the order passed in Annexure Roman 2?
yes, Lord.
Huh?
Yes, that is my grievance.
Annexure Roman 2 is making whom party?
These persons, Lordship, kindly see the petition itself.
Haidar Ali Abdul Noor.
Yes. Now they say some agreements have been executed with them by the legal heirs of late Golendra Momin, and therefore they should be impleaded as party
Have
defendants.
got interest in a part of the suit and measure.
That
in
is the
co-
issue, my lord.
Therefore, the
So we filed an objection, Lordship, which starts from page 25, stating that we have made the legal heirs of late Golendra Momin as defendants. So you are outsiders to the suit. Just on the basis of two agreements, they cannot be deemed to be necessary.
When did you file the suit?
Suit, Lordship, we filed in 2016.
These agreements were done subsequently.
These agreements, yes, my lord. And then, my lord, if the purported owners are there before the court, can someone, my submission, Lordship, on the basis of some agreement, can they be considered to be necessary and relevant party?
So now you wanted to make whom party?
Actually, Lordship, that is
Why have you made only 2% party?
No, my lord, there's one miscellaneous application which starts from page 31, Annexure 4. These are the legal heirs of late Golendra Momin, whom we prayed for impleading as party.
These means whom? Page 33, Labonyo Sukila Sama are as follow.
Yes.
Labinyo Sangma Sukila Sangma and Repella Sangma. Okay, then.
So
you made these three.
Yes, Lordship.
As parties. Okay.
So, my lord, in the miscase number 46.
So merely because they have entered into agreement pursuant to filing of the suit does not make them
that is
necessary
my
part.
contention, because if at all the defendants being the legal heirs of late Golendra Momin, they have interest, if it is determined by the trial court, their rights will continue. So why should they be impleaded as party defendant? So we objected. Now that the actual matter is somehow the learned trial court, Lordship, confused both the matters. Kindly read Annexure 5.
But what do you about the service upon these people? Now, if you are not affecting the service, how can we help you out?
Lordship, that is why I asked 7 days time, Lordship. And kindly have a look both the orders. The learned trial court.
No, Mr. Sharma, if you are not inclined to affect service upon them, we are not concerned.
7 days time.
7 days time, whatever may be, I'm not going to extend the stay. Let the suit proceed. I've already vacated the stay on the last. It is your party, your baby, you have to do it. You are not in a position to do it, then leave it. Forget about it. Let the suit proceed. They have been made a parties.
They have been made parties.
They have their lawyers.
In fact, none of the respondents here, Lordship, on whom notices have been served, none of them have appeared till now before this court.
Trial court.
Trial court, they appeared for a time.
Let them go ahead. We'll fix it after 1-2 months. We'll have it on 10th of June.
Yep.
And we'll ask the trial court to proceed.
Lordship.
Once they proceed with the lawyers, then I'll ask you to serve to the lawyers and effect the service. I think that is the only
In
way.
fact, my lord,
I am not going to
some of the defendants here have again filed another fresh suit
very well.
for
Let
impleading
them
this
file.
petitioner as defendant. That is also pending. All right, as lordship
Mr.
says.
A. Sharma, the learned counsel appearing on behalf of the petitioner, submits that he may be permitted to take fresh steps upon the response
1, 6, and 7, my
1, 6, and 7 by way of registered post along with 80.
Lordship, in the office note, as stated that also the usual process for the court of the learned Munsif at Mohan. I'll take step both ways.
As well as by usual process. 1, 6, and 7, na?
Yeah, 1, 6, and 7. That is what the office note indicates.
Who are the respondent number 2, 3, 4, and 5?
These lordship are the newly impleaded defendant pursuant to my mistake.
They have appeared. That's how it. So 1, 6, and 7, these we have nothing to do with 2 to 5
Lordship.
or 1. No.
Yeah.
Only as regards 6 and 7.
Lordship.
Now you know their service. Where are they from? Yokinga.
We have taken steps before also, but this neither the service, the acknowledgement have come nor
And what about the service by way of the stee? Can you do that?
that lordship without knowing the precise, that lordship may pass an order. I'll endeavor to take steps, but whether they can be pressed out or not. Sometimes these people who get into these land businesses, my lord, they give very picky addresses, which is so
No,
difficult
that is
to-
okay.
Yes,
They will file the application
yes,
and
yes.
you know that.
Yeah.
In addition to that, the petitioner is even given the liberty to take steps by way of the stee,
Yeah.
rooted through the registry of this court.
Yeah.
Upon the respondent numbers 1, 6, and 7.
lordship.
Full stop. This court, the record revealed that the interim order passed on 4/1/2021 was not further extended by this court on 22/3/2024. In view of the fact that the steps upon the main defendants have not been complete, this court is not inclined to extend the interim order. This is the matter again on 3rd of June.
Lordship. Third, can it be
10th of June.
10?
10th of June. Full stop. In the meantime, the trial court, that is the court of the
Lordship, the civil judge.
civil judge number
Senior
1,
Division number
Kamrup
1.
Metro at Guwahati, shall proceed with title suit number
22
322/2016 by effecting due notice upon the respondents, upon the defendants. Now, once they appear,
Lordship.
then we can.
Yeah.
In the meantime, if we can get this thing done,
Yes, madam. I'll do that.
Mr. Sharma, the A. Sharma, the learned counsel appearing on behalf of the petitioner, shall bring to the notice of the learned trial court the order passed today on or before 8th of April. 8.
8th of April.
You just draw it. Let
Yes.
the trial court proceed and
Yes.
give them notice. These people will immediately jump in. Then we can do something.
Lordship.
WPC 6138 of 2007.
You are there. So Kyle was there.
I was for the railway, madam.
Your name was there.
Yes.
Your name has to be inserted. Under such circumstance, this court is of the unhesitant opinion that the contracts in question to provide launch vessels would not come within the ambit of transfer of right to use the launch vessel. They are purely service contracts. Paragraph 42 of the judgment in the case as quoted above applies to the facts of the case. In view of the above analysis and observations made to the effect that there is no transfer of right of use of the launch vessels in favor of the railways, the contracts in question would come within the ambit of the service contracts as stipulated in section 65, 105, Z4ZJ of the Finance Act. The consequential effect of the said observation and declaration is that the impugned order dated T4/2017 stands set aside and quashed, and the clarifications so given by the respondent number 2 on 28/8/2015 and 6/5/2015 stands restored. The respondents therefore are further directed to act on the basis of the said clarifications. Clarification orders dated so and so and take appropriate steps for processing the application for refund of the petitioner as sought for at the earliest. In view of the above, the instance stands allowed.
May it please your lordship. May it please your lordship. I beg to mention item number 5 of today's list, daily list, your lordship.
5 is not done till now.
It is already done and it was dismissed, your lordship. Just, I beg apology before your lordship. It was fixed on 28/3/2024 and it was supposed to be listed on stay matter. It was a stay matter and it's supposed to be listed, item should come on stay matter, as a stay matter. But it was, today it was came on as an admission. So it is oversight for me. It was oversight and it is already dismissed by your lordship today.
Oh,
and
rightly done.
that is only my.
It is only
and
the timing would have changed for, it was done
also-
at 10:45 or 11. It would have been done at 11:30 when I started stay method.
It is just came to my notice just at 1:30 a.m. your lordship.
Isn't
And
this
it's a
the
very-
case of taking 10 adjournments?
There are circumstances, your lordship, and with that circumstance, I just assist your lordship.
No,
That
madam,
opportunity may be
sorry,
given,
I can't help.
and it was completely in the COVID period, your lordship. There are circumstances, your lordship.
I passed the order, you file a review. If you not going to change it. The ground which is already there, whether it comes for stay vacating or whatever may be, this can down. Yes, Mr. Chaudhary, your matter.
Master.
My lord, the National Commission has dismissed it on the ground of delay, my lord. And my lord, though under section 67, an appeal lies before the Honorable Supreme Court, my lord. But there's a recent judgment of the Supreme Court where the Honorable Supreme Court has taken the view. It's a recent judgment of the that we may either approach the High Court under 226 or 227 also. And let me kindly have a look at para 38. This document. 38. In the aforesaid view of the matter, we have reached to the conclusion that we should not adjudicate this petition on merit. We must ask the petitioner herein to go before the jurisdictional High Court, either by a writ application under 26 or by invoking the supervisory jurisdiction of the jurisdictional High Court under Article. Of course, after the High Court adjudicates and passes a final order, it is always open for either of the parties thereafter to come to court by a special leave petition seeking leave to appeal under Article 130. So this is how, my lord, we are before your lord. Here also was an order of the, my lord, National Commission, which was sought to be challenged under 136. paragraph 1 clarify that. And if your lordships may kindly have a look at paragraph 43, it is needless to clarify that we have not expressed any opinion on the merits of the case. Merits of the case shall be looked into by the jurisdictional high.
Finally come to paragraph 17.
Might. A plain reading of the aforesaid provisions of the Act of 1986 and Act of 2019 respectively would indicate that the remedy of appeal to this court is available only with respect to orders passed by National Commission exercise of power under section 12. In other words, both the acts provide for remedy of appeal to this court only with respect to orders which are passed by the NCDRC in its original jurisdiction as the court of first instance, and no further appeal lies against the order which are passed by the NCDRC in exercise of appellate or revisional jurisdiction.
Whether it will be an appeal arranged under 136.
Otherwise, there is no separate provision.
Let us see what does the
Actually, 136 is special leave to appeal. My lord, only when the SLP is admitted, then only it assumes the character of a civil appeal.
no, but whether it will be an SLP or whether it will be an
No,
appeal
any
under
appeal,
67.
Supreme Court first will have to seek leave, my lord.
No, when it is a regular appeal by the statutory authority, whether it will be under the statute.
But this is also an order under National Commission's order. My lord.
Understood. Can
Yes.
we kindly come to section this appeal? Otherwise, an appeal lies from which provision?
Against a revisional jurisdiction, no appeal lies. That's what the para 17. Here is an order which is passed under revisional jurisdiction.
Because
in other words, both acts provide for remedy of appeal to this court only with respect to orders which are passed by the NCDRC in its original jurisdiction as the court of first instance original order, and no further appeal lies against orders which are passed by the NCDRC in exercise of appellate or revisional jurisdiction. Here in this case, in exercise of revisional jurisdiction, the order was passed.
so this was done under 58B. And as such, 220. I also thought that because 67 is only 50
Fix of appeal from
subclause
original
1
order.
and 2 of subclause A.
Yes.
So therefore you can come up.
Yes.
Yes, now tell me.
My lord, what had happened? The respondent complainant, he took a loan, my lord, of 6 lakhs from the appellant before, from the petitioner before lordship. Since he defaulted in repayment of the loans, my lord, invoking the hire purchase agreement, my lord, we repossessed the vehicle. Now that was found to be illegal by the district forum as well as by the state court. Whereas the Honorable Supreme Court of India has already said, my lord, this is permissible. Because in a hire purchase situation, my lord, it is the financier who is the owner of the vehicle.
No, we are concerned with the delay of 1402.
Delay is substantially long, my lord, 1402 days.
Why?
Because, my lord, the person who was in charge, several factors. In fact, my lord, if your lordship will kindly come to page 85, where the National Commission dealt with it, my lord, there the reasons are considered.
Yes, what is your ground for delay?
Now, if a lordship should kindly come to page 84, my lord. In fact, the application which was filed before the National Commission, my lord, is expected. A, that the impugn order was passed on 25/6/2018. However, due to certain miscommunication and technical lag, the status of the case was not updated with the head office of the petitioner, which is in Chennai. Hence, for a long time, legal team of the petitioner in Chennai had no knowledge of the status of the case. That when the legal team at Chennai main office got to know of the status of the appeal before the learned Assam State Consumer Dispute Redressal Commission, Guwahati, the petitioner thereafter had attempted to file a revision petition before this Honorable Commission. However, the appellant in-house legal assistant, house legal assistant who was looking after the present matter expired on that period, and all the relevant documents was in his custody, and the petitioner were not only been properly communicated regarding all the documents from his custody after his certain death. Therefore, the unintentional delay was caused to locate the records of the case and retrieve all the case files. The precious time was taken as the communication was being held across 3 states, that is Delhi, Guwahati, and Chennai, Tamil Nadu. Therefore, unintentional delay was caused to locate the records of the case and to retrieve all the case files, etc., etc. Thereafter, due to coronavirus outbreak, the nation saw lockdown, and graciously the Honorable Supreme Court right ordered it directed extension of the period of limitation till in all proceedings before the courts and tribunals.
Now, okay, you will get the limitation break.
Yes.
The judgment was on
on merit-
25/6 to 2018.
Yes.
Till 15/3/2020, you will get the benefit. When did you file this application?
One second. Original complaint. In August 22, my lord.
So you have 1 month from there, or 90 days. How much is the limitation for filing the revision petition?
90 days.
90 days. So from there, 90 days. So from here, March, April, May, till 31st of May. Thereafter, 2 months. Okay. Then what the reasons which have been given from 25/6/2018 till 15/3 is only A and B.
Yes.
But there is no details.
No, in
Who filed the appeal before the division before the Assam Consumer Retrieval Forum?
national matter.
No, in Assam.
State. Yes.
In the state. Who
Yes,
filed?
yes. 1 second. Hello. Page judgment 55 petition. Judgment, lordship is referring to the judgment, my lord. Judgment of the commission is dated
President of
25/6/18.
Consumer Forum at Dibrugarh.
No, my lord, the state commission's order is at page 55.
Yes,
The
you
delay
filed it.
occurred from this date. my
So
lord.
the appeal was filed by you.
Yes.
So you knew everything.
Yes.
How can you say that you didn't know anything?
No, man, we filed the appeal. That's true, my lord. But thereafter, my lord, there was a communication gap.
Then it is negligent.
Only thing is, lordship will.
It's a clear case of negligence, Mr. Chaudhary. You see, these are consumer forum disputes. Needs to be as early.
No, my lord. One more thing I may just indicate, my lord. My lord, that the money which he owes to us, that he has not again taken care of.
Rightly or wrongly, yes, you need this was passed in 2018. You were the appellant. Unless you allege some problem with your advocate, how can you say anything all this thing?
Person died actually, my lord, who was dealing after all.
Understood
Thereafter,
that was
that was followed
there is
by
no
COVID, my
mention.
lord.
You see, kindly see the reasons. You have not mentioned a single word. When did you come to know about that judgment? Nothing. Nothing is there.
My lord, if the lordship will kindly come to paragraph 13, page 13, my lord.
No,
Para
this
one-
is your petition here. I'm not concerned with that. We have to see as to 227 whether this court should exercise the jurisdiction.
My lord, True, my lord, I am not technically saying that court acted here out of bounds or something. Just, my lord, to invoke the jurisdiction, my lord, in terms of the Supreme Court.
Because
order.
this is a matter pertaining from, you see, a person's right from 2012. 12 years have now passed by.
And one more thing, my lord, that the money which is due to me, that aspect has also not been taken care. At least they
That
should
is-
offset the money which they owe to us.
That is on merits.
There is some benefit.
You are a big Hindustan finance agency, do whatever you like.
Not a very big thing, my lord. Not a very big one. So true, my lord, I think the explanation ought
think
to have been little
It,
bit
it should have
more
been better.
elaborate.
It should have been better drafted that yes, we didn't know from there. Nothing is mentioned. I'm if I issue a notice, this is only further going to only delay the again.
Only thing is, my lord, tomorrow our director's presence has been ordered. So lordship should kindly issue a notice at this
Yeah.
stage. Before my lord district of approval. The lordship will take care of that, my lord, and issue notice at this stage. The warrant has been issued. Earlier it was issued, the date was fixed on 22nd of February. Now it has been extended to tomorrow, my lord. That statement we have made in paragraph 17, my lord. Para 17. That in the meantime, London District Commission might order dated issued bailable warrant of arrest against managing director and deputy manager, so and so, the present so and so, so and so. This is there.
I can only take care if you make the payment on the next day. I'm not going to issue notice.
My lord,
I'm not going to issue notice.
no, my lord, our only anxiety is, my lord, let the money which is due to us that we offset against this will pay. Definitely when there's an order of the court or a tribunal, my lord, what we propose to do
You pay
for
by
the present sum.
You pay by 15th of May. I fix it there.
And the district, whether I can pay for that or not. The
No,
time-
I'll stay everything till 15th of May. I'll say not to take any action. I'm dismissing this petition, but giving you the liberty till, okay, make it.
No, my
22nd.
lord, the 15th of May is okay. I'm not on the time part. Only thing is, my lord, the loan which he has taken, that he has not paid. At least the principal amount he should, my lord, pay with the current interest. That should be offset against this.
Wouldn't that be touching on the appeal merits?
No, my lord.
Yeah.
That's an aspect which the district forum as well as state commission, my lord, totally ignored.
Understood.
And my
But
lord, legally
again,
speaking,
touching on the merits again.
my lord, I'll just place one judgment of the Honorable Supreme Court, my lord.
Mm.
Thank you, Professor Judge. Take a hold that. Hey, thank you. Small paragraph, my lord. This law is well settled. I don't know, my lord. Even National Commission did not interfere. Of course, National Commission did not interfere on the ground of delay. As a financier, I am the owner, my lord. Where is the question of constructive possession in any case is with me? That's the law. My lord, normally in delay matters, lordship also takes note of the merit of the case. That's why I'm saying, my lord. Let the other side appear, my lord. Let them say what they would like to pay.
But I'm not staying it.
My lord, that warrant part.
No, nothing. You appear before that. I'm not. First of all, this court is not. I don't have any. Yeah, issuing of notice out here would not be the weight of not issuing a notice is much more.
So Lordship will give us time. Till 15th of May.
I give you to 1st of June.
Okay. And my lord,
You
Lordship
make the
will,
payment.
Lordship will keep it open regarding our claim also, that will take up the matter in the appropriate court.
That you can. I think
Keep
that
that
you
issue open.
Yeah, keeping the issue open.
Yes.
I'll make it very clear that as regards your entitlement,
Yes.
you can very well agitate, take
In an
due
appropriate
recourse
forum.
to as per law. You pay whatever it is, but you have the right to take recourse. I think that is a better.
My lord.
This is an application under Article 227 of the Constitution, challenging heard Mr. Kane Chaudhary, the learned senior counsel, assisted by Mr. So-and-so, Ellen Dihania, the learned counsel, appearing on behalf of the petitioners. This is an application under Article 227 of the Constitution, challenging the order dated 17/11/2023, passed by the National Consumer Dispute Redressal Forum, for short, NCDRC, in IA number 6840/2022, arising out of revision petition number 941/2022. Before proceeding with the disposal of the instant application, this court finds it relevant to take note of the judgment of the Supreme Court in the case of MS Universal Sompo General Insurance Co. Limited versus Suresh Chand Jain and another, reported in AIR 2023 SC 3699, wherein the Supreme Court had categorically observed that the proceedings that against an order passed in exercise of the powers under Section 58 of the Consumer Protection Act 2019 and a proceedings under Article 226/227 of the Constitution of India is maintained. So, taking into account the above, this court therefore proceeds to take up the instant proceedings, entertain the instant proceedings. It appears from the materials on record that a complaint was filed before the District Consumer Forum at Dibrugarh by the respondent herein, which was registered and numbered as CP case number 26/2012. The said case was disposed of by the judgment and order dated 23/3/2015, whereby the learned court, learned consumer, the state district consumer forum came to a finding that the respondents, the petitioners herein, who were the respondents in the said proceeding, have came to a finding that there was deficiency in service by the petitioners herein, who were the respondents in the said proceeding, and accordingly and therefore imposed a consolidated compensation of rupees 12 lakhs along with interest at the rate of 7% per annum from the date of claiming till realization for the loss of the assets, semicolon, mental loss, comma, pain and suffering. And the petitioners herein were directed to return the unused checks to the complainant, the respondent herein. The said amount was directed to be disbursed within a period of 2 months from the said date of the judgment. Being aggrieved, the petitioners herein, as appellants, preferred an appeal before the Assam State Consumer Redressal Commission at Guwahati, which was registered and numbered as First Appeal number 18/2015. The first appeal, the State Consumer Redressal Forum, by an order dated 25/6/2018, having not found any merit in the said appeal, dismissed the appeal by categorically holding that there was deficiency in service committed by the petitioners herein who were the appellants. Thereupon, no second appeal was filed against the said judgment and order dated 25/6/2018, but a revision petition was filed, being revision petition number 941/2022. There was a delay of 1402 days in filing the said revision application. And as such, an application seeking condonation of delay was filed, which was registered as petition number 6840/2022. It is relevant to take note of that the revision was filed on 22/6. Revision was filed sometime in the month of August 2022, as submitted by the learned counsel appearing on behalf of the petitioner. It has been brought to the attention of this court that although the judgment and order dated 25/6/2018 was passed by the State Consumer Redressal Forum, but on account of certain miscommunications, the said revision could not be filed. Further to that, the in-house legal assistance had also expired, and various documents could not be traced out. The learned national and the learned NCDRC, by the intune order dated 17/11/2023, had rejected the said application for condonation of delay of 1402 days. And it is against the said application, the said rejection dated 17/11/2023, the petitioners have approached this court by filing the instant proceedings. This court have also, it has also been submitted by the learned counsel appearing on behalf of the petitioner, drawing the attention of the order dated 4/1/2024, passed by the Delhi District Consumer Dispute Redressal Commission, Dibrugarh, that bailable warrant has been issued against each of the managing director, each of the petitioners, that is the managing director and the deputy legal manager of the petitioner. And as such, against the execution of the said judgment passed by the District Consumer Dispute Redressal Commission. The learned counsel appearing on behalf of the petitioner further submitted that by the order dated 22/2/2024, a fresh bailable warrant was issued, thereby fixing tomorrow, 2/4/2024, for appearance of the managing director as well as the deputy manager, legal manager, on the basis of a bailable warrant. Next. In the backdrop of the above, this court have duly heard the learned counsel appearing on behalf of the petitioner, Mr. K. N. Chaudhary, have duly heard Mr. K. N. Chaudhary, the learned senior counsel, appearing on behalf of the petitioner, who submitted that the learned the learned state the learned district consumer dispute redressal commission, as well as the state consumer dispute redressal commission, completely failed to take into account that the petitioners herein were entitled to various amounts from the respondents, from the respondent / the complainant, and that amount was not set off while passing the award of compensation. He submitted that this very aspect ought to have been taken into consideration either by the national NHRDC as well as by this court while entertaining the instant proceedings. The learned counsel further has drawn the attention of this court to the order passed by the Supreme Court in the case of Tulyapal Singh versus Siddhi Vinayak Motors and another, reported in 2012, 12 SCC 355, wherein he submitted that it is the well-settled principle of law that that in a hire purchase agreement, the financier is the real owner, and as such, there cannot be an allegation against him for having possession of the vehicle. The learned counsel further senior counsel further submitted that in view of the said law, the learned both the District Consumer Dispute Redressal Commission as well as the State Consumer District Redressal Commission had committed grave error in law. On the aspect of delay, which is the subject matter of the question, the learned senior counsel submitted that it was on account of certain miscommunications which had resulted in such delay. Be that as it may, the learned senior counsel submitted that it is the requirement that such a it is the requirement that while deciding on the delay, the court is required also to look into the merits of the dispute. Having heard the learned counsel for the petitioner, this court is of the opinion that as this court is entertaining a proceeding under Article 2 to 7 of the Constitution only on the question as to whether the learned NHRDCA had committed an error of law, jurisdictional error of law, in rejecting the application for condonation of delay, the question that the submission so made on merits has to take a backseat. Therefore, the question arises as to whether the learned NHRDC was justified, had committed any jurisdictional error in dismissing the said application, which was delayed by 1402 days. This court have duly taken note. This court have perused the impugned order. And from a perusal of the impugned order, it is seen that the learned the NHRDC have duly recorded the contents of the application which was filed for condonation of delay. This court have also taken note of that the appeal was filed against the judgment passed by the learned District Consumer Redressal Forum by the petitioners herein. The judgment in the said first appeal was delivered on 25/6/2018. The contents of the application, which have been reproduced in the impugned order, do not speak anything as to when the impugned order was received by the petitioners and why. Even prior to 15/3/2020, no action could be taken. Though there is the mention about the legal assistance having expired, but there is no mention as to when the legal assistance had expired, and also no relevant documents have been placed. Under such circumstances, how the death of the legal assistant had impaired the petitioners to approach the NHRDC to file their revision application within the time stipulated is not known. Consequently, this court is of the opinion that the impugned order dated 17/11/2023 does not call for any interference, more so in a proceedings under Article 2 to 7 of the Constitution. Next. This court have also duly taken note of the order dated 4/1/2024 passed by the District Consumer Dispute Redressal Commission, Dibrugarh, whereby bailable warrant has been issued against the petitioner, against the managing director, as well as the deputy legal manager of the petition. It has been also brought to the attention of this court that 2/4/2024 is the next date. Mr. Kane Chaudhary, the learned senior counsel, appearing on behalf of the petitioner, duly submitted that some time may be given to the petitioner to pay the amount as per the order passed by the District Consumer Dispute Redressal Commission. And the petitioners should also be permitted to claim their dues in accordance with law. The learned senior counsel further submitted on instructions that if Yes, when?
First of
Not the first. Let's have it on 5th of June. After the election result.
electoral
By
votes
5th of
electoral votes are no longer.
by 5th of June 2024, on or before 5th of June 2024, the said amount shall be duly the amount as directed to be paid by the District Consumer Redressal Forum in its judgment and order dated
23/3/15, 23rd of March.
judgment and order date 23/3/2015 shall be deposited in the consumer
In the registry of that consumer.
deposited before the district consumer disputes redressal commission Dibrugarh. Until then, no coercive measures be taken against the petitioners. This court, having given an anxious consideration to the said aspect of the matter, is of the opinion that in the interest of justice, certain protection is required to be given to the petitioners. Accordingly, this court directs the petitioners to pay this court on the basis of the said submission, grants the liberty to the petitioners to pay the said amount as directed by the judgment and order dated 23/5/2015.
23/3/15.
2015.
23rd of March.
On or before 5/3/2000, on or before 5/6/2024, before the District Consumer Dispute Redressal Commission, Dibrugarh. Till that time, no further coercive measures be taken against them. This court further observes that the direction to deposit the said amount, which the petitioners herein have duly undertaken to deposit, would not come in the way of the petitioners' claim over any actionable claim against the respondents, if otherwise permitted.
Hello, 14 stay matter.
Made with the law. Is a transfer petition by the petitioner who is the wife of the respondent, seeking transfer of a divorce case pending in the court of family court Kachar to Hailagandi, the hometown of the petitioner. After getting from the husband's house, he is staying with her father at Sarachara estate, situated village in Hailagandi. And already two other cases are pending. The Lanet court of the Lanet of Hailagandi. The respondent is also contesting the case there. Two other cases are pending.
Where?
In Hailagandi.
What cases?
One is a case filed by the petition under section 498A, and the other one is a proceeding under section 125. They are seeking maintenance of the response. Both the proceedings are now going on in Hailagandi.
The first is
498A proceeding, and second one is 125. They are seeking. Thereafter, the divorce petition has been filed in Secretary of Kachar district by the husband.
Paid by what? Paid the kids. এটা pending আছে। You have filed your written statement?
Yes.
Written statement. It's me. Appear in the district court, district judges in Hailakandi and file your written statement on that. Hello.
Lordship, the impending order is number 73 to 88, Lordship, 24/3/2023, Lordship. And prior to that, the notice, Lordship, are coming to that part, Lordship. The petitioner is entitled, the dependent is entitled for the loan amount of 2 lakh, and against which the petitioner has paid 2,48,000 that amount in his account from time to time. So that is in the there. That concept comes to page number 42, Lord. Page number 42. Wherein he said that it is true that on 10/6/2016, I paid only 2 lakh to the dependent during cross.
You asked for re-examination.
Yes, Lord, if the bank witness come, bank witness, he deposed. But during cross-examination, he admitted it. Statement about the amount has been deposited in our account. From time to time, 2,48,500 paid. And the deposit slip, the counterfolio deposit slip, in which page number 66, by which we are deposited.
You are the defendant.
I'm the defendant.
And now TW1 has come. You wanted the re-examination.
The re-examination, because that kindly come to see it, cross-examination, Lordship, page number 55. He said that 55 last portion. He said the bank statement card is admitted that these are the deposits have been made in the account of the dependent this amount. But he later on cross-examination, he said that only the casiers of our branch can say about the deposit slip or counter folios. The exhibit D.
And when did you file your application? This was done in commission.
No, in court.
Then why didn't you say at that point of time?
No, that I said that part.
Why didn't you ask for re-examination then and there?
No, I filed the application there.
When?
That is, Lordship.
Was it the next date?
That page number 69.
Now, when did you file it?
This is filed on 7/11/2022.
When was the cross done?
Cross was done. Eight 2022.
Huh?
8/8/2022.
What happened to the next 3 months?
The date was fixed, Lordship. That's why this application was filed. Because I have duly deposited the amount. Duly the pay amount 2 lakhs again 2 lakhs. I have paid the amount. And statement about
Mr.
Yeah.
Sharma, all these things are not going to help me. The only thing, if you have anything to say, is why did you take 3 months to inform the court that you want to re-examine? And what is the stage of the suit then?
The case, the suit is still, Lordship, that is in page number.
No. What is the stage of the suit?
It was a DW.
DW.
DW has already been concluded and now it has been
No.
fixed for hearing.
Wrongly, court has concluded the DW and fixed the matter for argument. This is like, kindly see the order dated 23, page number 49, page number 49, London. That was allowed, page number 49. 5/5/2022, during presentation in the petition, I filed a petition that time, defendant paying for deferring the evidence due till disposal of business case, heard both sides, whereas is allowed. When
Why are you referring to all those things? We are not concerned about this. This happened
DW.
on, this oath was taken on 8th of August 2022. What happened thereafter?
the next
Where is the order of 8th of August 2022?
Yes, sir. Then the date was fixed. On that day, the application was filed because I paid the amount. Look. I paid the amount 2,48,500. I paid the amount in his account. Statement about exhibit C was exhibited by the bank manager, and deposit slip
The bank may say the cashier has signed, I do not say that part. So for that, I am suffering lot. I paid the amount with interest, everything. And the further DW's court has to fix the date.
Then very well argue the matter before the trial court. Why do you need to react that?
Now, only that ambiguity was created. That case.
So why didn't you say at that point of time, you were very much present in the time in the court, that yes, this ambiguity is there for which I need to file an application, or allow me. Then you did, the court may have said, okay, you file an application for re-examination. Why did it take 3 months thereafter?
Whether that application was immediately filed or not, that is not, but that order 18 rule 7 application was filed, and order 18 rule 17 application was filed. Court has said that this to fill up the lacuna. That was said. I have deposited the amount.
Where is the order 18 rule 17 application?
This is not. Page number 69. Page number 69. Now look to that part. In her account, I have deposited that amount. There is no to that.
Order 18 rule 17 is for additional evidence.
No. Just to
for recalling.
Recalling the cashier, because bank manager come up. He exhibited the deposit slip and said that these are true. Nothing false. But process he said that part that regarding the, because it handles by the cashier. And as such I cannot. But statement about the value amount is deposited. The statement of account in which is submitted, there is.
Why did you require 3 months to do that? Secondly, you are filing an application under order 18 rule 17. How can it be on the basis of a verification?
Just to that part, that cashier, he can clarify. No. Otherwise, I will lose. The amount have been paid. And statement account is very much there. For that, I will suffer only unnecessary. You know, 50 businessmen, he took 2 lakh loan, and against which 2,48,500 deposit in her account. The earliest he did not complain, did not disclose that part.
You are the plaintiff or the defendant?
I'm defendant.
So, your witness comes up and says that.
And this is for technical part, if we think little bit, because only that is not that there is no amount.
First of all, why did the court at all entertain your application? Ask such a long order. The court should have, on the face of it, first day itself dismissed it. We now dismissed it, and the court did not. Did the court impose cost upon you?
And instead of DW, for the DW court has to for argument. The court is page of 49.
Now, did you have any other list of witness?
Yes, but the bank, I have list of witness, the plaintiff and one person, his employee.
How can you have a list of witness of plaintiff?
Yes,
you are the defendant.
Yes, list of witness I have enclosed also.
Show me the list of
witness. That is page number 37 or 38.
Huh?
37, 38. Two list of
we are not concerned with the
36 is plaintiff.
You are the defendant.
30, yes. Dependent is 37. Ranjan Barua, dependent, Nilu Nayak, employee, and others.
Who is Nilu Nayak?
Nilu Nayak is employee. Who also goes.
Has Nilu Nayak given?
Yes. No, DW has not been submitted. Because the court stayed by order date 5/5/2012 to the further proceeding. DW was kept in abeyance. Immediately, the bank witness was called for by filing misjudged case to clear the ambiguity.
Bank witness was not a DW.
No. Court has recorded kindly. That is also.
Then why is your petition saying about DW1?
Yes,
it was DW1, madam.
Let's kindly see that part. One thing, one aspect, kindly see that.
No. Your petition. No. Why you have to recall the DW?
No, court has taken as, because kindly see, court has taken as agent
Mr.
DW.
Sarma, kindly see page 70 of your application. What is your prayer? What is your prayer?
Page number 70.
Yes, 70.
Yes, it is a prayer the honorable police to admit this to the father police to DW to clarify the ambiguity made
So,
in the deposition.
Is your DW? Well,
but other DW of plaintiff and pleading was issued by 5/5/2022.
so you say that the DW has not come. You are saying that he is a DW. Kindly see the paragraph 3. Defendant further submits that the evidence of DW1, Prince Paul Singh, the bank manager of so-and-so, was recorded by the Honorable Court. This is your entire case. And you are saying that DW has not come.
On the basis of the petition which case I submitted, that was allowed to call the clarify the ambiguity, that is page number 44. Can you see the page number 44?
And this name is some Pranjan Borua.
Pranjan
Pranjan
Borua
Borua
is a
and this
defendant.
person is different.
No, Pranjan Borua is defendant. Pranjan Borua is defendant in the instant case.
You are the defendant?
Yes.
What is your name?
Pranjan Borua.
What was the suit for?
Suit for recovery of money and interest thereon.
Are you challenging this order for closing your evidence?
No, my
Or is it only limited to order 18 rule 17?
I'm really here in 18 rule 18 and 17.
Not for fixing for arguments.
Not that I have stated.
Are you challenging that portion or not?
My claim. Page number 10, page number 10.
Mr. Sharma, you read your brief properly.
No, that is,
You don't know
in
head or
prayer
tail
portion,
about
I
your
have not
case.
mentioned that. In prayer portion, in my plaint, in prayer portion, I have not mentioned that part.
What have
But
you
in
asked?
paragraph, I have mentioned. In page number 10, above, it is mentioned, but actually the DW was deferred till disposal of miscase. As a suit was fixed for DW in compliance to order date passed by the learned court bill.
He was actually a bank official witness of the PW. He's not a DW.
No, that's why I have to the order in page number 44.
Why was it made a PW? Where is his evidence?
That is in
Where is his evidence?
bank witness.
His evidence.
Yes.
That person's evidence.
But he was the DW, my lord. He has called him
Who called him?
for filing an application, he, my lord.
He called him.
Page number 51 is the
Was his-
application, my lord.
8.
51 is the notice, my lord. And
Page 51.
is the notice issued, my lord. And his application is page number 44, my lord.
No, where is his pro?
Cross is
DW1.
53.
Cross 53, my lord.
It
54.
is his witness only.
His witness, my
54,
lord. He has called it.
54.
Application is at page number 44, my lord.
Cross is page number 54.
But he has the right to give his evidence. He has not given his evidence. That I think
that
needs
is
to
there.
be done. But we are not touching on this.
That is the only mere agreement. I have deposited, that is admitted part. Only say the cashier quoted fairly 2 lakh against 2,48,000. This is an
Mr.
admission.
Counsel, I don't have so much of sympathy. I have sympathy that you should be given evidence, that's all, but nothing more than that.
Yep.
Now, this is an application under Article 227 of the Constitution challenging the order dated 24/3/2023 in money suit number 60/2017, whereby the application filed under Order 18 Rule 17 of the Code of Civil Procedure 1908, for short the code, filed by the defendant, who is the petitioner herein, was rejected. Stop. This court have duly perused the evidence on the evidence of DW1, which have been enclosed as an annexure Roman 12 to the instant proceedings. Full stop. The DW1 is the branch manager of Punjab National Bank, Simulguri branch.
United Bank of India.
Huh?
Later on, it is been Punjab National Bank.
It has been mentioned as Punjab. Mr. Sharma, you don't know all these things. Don't say all these things. It's written out there.
Now it is
Mr. Sharma, it is written out there in page 53. Or are we to dismiss it on the ground that you have given a false document? You have given a false document. That means when it is written out there, are you not? What do you say about this document? It is wrong. Are you saying this document is wrong?
no, not a single
Then it's written out here, branch manager PNB. I am not concerned with earlier, before, or former. It's written out here, whatever is given out here, I am writing it. Punjab National Bank, Simulgur. The evidence of the said witness was taken on 8th of August 2022. Thereupon, it is not known as to what transpired or what steps was taken by the defendant. But on 7/11/2022, that is almost after 3 months, an application was filed under Order 18 Rule 17, read with Section 151 of the Code, to recall the said witness in order to clarify the ambiguity made in his deposition. There is nothing mentioned that at the time of cross-examination, at the time of the examination of the DW1, the defendant had sought for re-examination before the trial court or immediately thereafter. It is only seen from the said application, which was filed on 7th of November 2022, that this application was being, that the witness was to be recalled to clarify the ambiguity made in his deposition. Objections were duly filed, and the learned trial court, by an order dated 24/3/2023, had rejected the said application. Mr. Counsel, why can't we allow this recalling only, but the court will then decide as to whether he's trying to fill up the lacuna or not?
Well, the moment an order is passed by this honorable court, it has to be whether rejection of this, interfering with this particular order, as to recalling my lord. Thereafter, my lord, certainly he would be called my lord.
Therefore, the question is, the court has come into an opinion that he is going to fill up a lacuna. Whether it is a filling up or lacuna or not, it will be only done at the time of asking the re-examination. how can he say the trial court come up without the question being put?
My lord, if I may, my lord, the cross-examination, firstly, at the time of cross-examination, he was there, my lord. If something has to be asked, then he could have very well asked that particular application. He had waited for one more day. The he was cross-examined on 8/8, if I'm not wrong, my lord.
No, Mr. Counsel, I am not on that.
My lord.
The reason is not that his conduct is atrocious. Let us assume. Like his counsel is the defendant's counsel is defendant's conduct is atrocious. But you see the reason given at page 87. That doesn't inspire the confidence of this court. We allow it subject to a cost of 50,000. And to be paid by Mr. Bishambar Sharma to you. No, I'm serious. Misleading the court. In this ground, if I say today is right, how do you say that? Absolutely wrong. It is against the very tenets of Evidence Act as well as recall. How will the heir know whether he is trying to recall or not? Well, fill up the lacuna, he can very well decide that whether it amounts to filling up the lacuna.
But at this particular juncture, my lord, it will be difficult on my part as to what boundary would be set
No,
to the
it is
lower
for the
court, my lord.
court. The court will decide.
If that issue is left
No,
open, my
that
lord,
is
then-
for the court. I'm not that, but I will allow that application and the court will decide as to whether after re-examination, which part is to be appreciated, which are not. Within the contours as to how far a re-examination can be allowed. It cannot be permitted for filling up our lacuna, but for clarification is permitted. Say that. This court have duly perused the impugned order dated 24/3/2023. And the learned trial court have rejected the said application only on the ground that if the recalling of the witness is permitted, it would amount to filling up the lacuna. It is, however, not understandable as to how the learned trial court could have reached the said opinion without even recalling the witness. And the question and the witness being again, and the witness being and the witness being put to examination. The law as regards re-examination of the witness is very clear. The re-examination of a witness is permissible only for the purpose of clarification, for the purpose of clarifying the ambiguity.
If I may, my lord. Page number 69, my lord, is the application. Paragraph number 4, my lord. He's only on this particular appointment. Whether this
Understood, but then also let him put that question to him. For clarifying the ambiguity. And not for filling up any lacuna. Clarifying the ambiguity which has arisen during the course of cross-examination, but not for the purpose of filling up the lacuna. Under such circumstances, it is the opinion of this court the learned trial court ought to have allowed the said application so filed. And at the time of appreciation of the evidence, while writing the judgment, the learned trial court ought to have taken a decision as to whether that re-examination so carried out was for the purpose of, was filling up the lacuna or was in relation to clarifying the ambiguity. Accordingly, this court interferes with the order dated 24/3/2023 passed by the learned trial court in petition number 5179/2022 dated 7/11/2022 and permits the learned trial court and directs the learned trial court to recall the DW1 footstep. The learned trial court, during the examination of the DW1, shall take due note of the questions being put to him and permit and questions being put to him as to whether the said questions pertains to clarification of the ambiguity or in relation to the filling up of any lacuna. The learned trial court shall further be at liberty at the time of delivery of, at the time of writing the judgment to appreciate the evidence in accordance thereof. With the above, the instant petition stands allowed. The interim order dated 3/5/2023 stands vacated, and the parties who are duly represented before this court are directed to appear before the trial court on 2nd of May 2020.
I will make a prayer, my lord, a little observation. As it is his witness, my lord, if he puts on something new, then it might be, if I may be allowed to cross-examine. That may be, my
It
lord.
is made clear. There is one direct judgment on this point, exactly on this point. It is further made clear that in the eventuality, the plaintiff and the defendant brings new materials on the basis of the examination. The respondents who are the plaintiffs would be at liberty to re-examine, to re-cross-examine the plaintiff, the DW1. In fact, there is a direct judgment on this point. So this court further imposes the cost of rupees 50,000 upon Mr. B. Sharma to be deposited before the raised 5,000. 5,000 for making unnecessary stuff. 5,000. Pay something to the legal service for troubling this. You don't read your paper properly. Show me the judgment on which that judgment is there, which permits it. Show me the judgment. You just come to the court just for the sake of throwing a petition before the court. We don't expect this type of advocacy. Like, yes.
I have a quick question here.
In a eviction suit, my lord, the landlord filed it. If parent, my lord, is sick from prior to the death.
It cannot be. The parent will be only fixed from the date it is fixed. The law is very clear on that.
And the tenant cannot be found as defaulter, my lord.
No, for that it cannot. It will be, the parent will be only from the date it is fixed. It can't be before that. No. It is nowhere stated in that.
So there is the division bench order saying that the parent can only be fixed at the most on the date of the application, not prior to that. That law is separate.
And then then also that cannot be a defaulter.
No, cannot. The liability would only accrue from that date. If I may just pass on.
Not necessary. I think I know that.
Just go with it.
Not necessary. Mr. J.N. Sahiwala, the learned senior counsel, submit. This is an application under Article 227 of the Constitution challenging the order dated 15/7/2023 passed by the learned court of the Munsif number 2 Tezpur, Sonitpur in midday case number 129 of the 2022 arising out of title suit number 95 of the 2020. By the impugn order, the learned trial court directed initiation of proceedings under section 3 and 4 of the Assam Urban Area Rent Control Act 1972. It being a well-settled proposition of law that the fair rent can be fixed only from the date of the application, and there cannot be a case of a defaulter in payment of rent as regards fixation of the fair rent prior to fixation of the fair rent, the learned counsel appearing on behalf, senior counsel appearing on behalf of the petition does not want to further press the instant proceedings. Your only quarrel was taking into account the well-established principle of law. In that regard, he refers to the judgment of the division bench of this court in the case of Surajmal Mangilam versus legal heirs of deceased Kanhayalal Agarwal, reported in 2010 to JLR 198. Taking into account the above proposition of law, the instant proceeding therefore stands closed on withdrawal. It is made clear that the fixation of the fair rent as directed by on the basis of the proceedings initiated by the impugn order dated 15/7/2023 shall be based upon the fixation of the fair rent with effect from the date of application of filing of the application for filing of the fair rent, and not on the basis of the cause of action for filing the suit.
The application for fixing the fair filing.
The application for fixation of the fair rent.
Because only defaulter cannot be mother prior to fix.
That is what I say. Read it. cause of action for the filing of the suit is different. So it cannot have an impact on this.
Correct, my lord, and moreover, on the date of the filing of the petition also, can pay that debt, my lord, but for that period also, I cannot say, tell you it.
It is also observed that if any fair rent is fixed above the rent which was the rent earlier paid, the petitioners, who are the tenants, shall not be held as defaulters if within us held as defaulters, unless specified applications are being filed in terms with the judgment of the Supreme Court of the division bench of this court in Sobha Withdrawal versus Joinder.
46.
You give the citation of Sobha.
I'll give.
You are there.
Lordship, my item number is 40.
40.
140.
Huh?
140.
14. We are reaching 14 very soon. But who is there in this 141? Is a good case. P.K. Roy Chaudhary. Nowhere to be seen. Oh, this is for service is not complete. The service being not complete. The office note reveals that no steps have been taken pursuant to obtaining the stay order from this court on 18/12/2023. Under such circumstances, this court fixes the matter again on 29th of April 2024. This court is not inclined to extend the interim order passed in the instant proceeding. It further made clear that if no steps are taken in the meantime, the instant proceeding shall be dismissed.
And 15 for order.
14, what has happened? 15 is what? Order 41.
Order 41, 11, your lordship. It's simple matter.
Show me what is the simple matter. After sitting for 1 month, this is the first order 41 to delay. Yes.
What happened, your lordship? This is the matter. If father is the donor,
Huh?
father is the donor. In favor of fund, your lordship is the donor. So by two registered gift it, your lordship, he made a gift of 1 kata 10 letters of lamb to his son.
To his son.
To his son, your lordship, Doni. And Doni and the father and his wife, the other brothers and sisters lived in the same campus, your lordship, the same household. It's a family. Now, question is, your lordship, the different number 1, 2, and 3, these are the persons who have admitted that there is a
there is a gift, your lordship, executed and registered by your father, your lordship, and the husband of different number 2, your lordship, that is distributing your lordship in favor of the son. That is to that effect, your lordship, written statement and the evidence is also clear. So I adduce evidence, your lordship, to the that I accepted on being declared the gift, your lordship, and possession was also delivered in presence of witness on Sharma, your lordship. The learned court below, your lordship, has taken a view, your lordship, that on the date of execution and registration of the sale deed, gift deed, you were not present inside the sub-register's office. So there is no acceptance. That's why there is no acceptance. So delivery of possession is also not there. That's why it is not perfect. Whereas there is ample evidence, your lordship, that there is evidence by the witness, your lordship, that is called Satyendra Prasad Sharma, your lordship, is stated, your lordship, that I know the donor since long back, and he called me that it's that, your lordship. And in case of your lordship, the law says under section 152, subsection 3, your lordship, that in case of a property where the donor and the donee live together, your lordship, formal delivery of possession is not necessary. And the father, your lordship, did not depart, your lordship, go away with bag and baggage from there just to release the property in favor of the. But the trial court, as the first appellate court, your lordship, did not consider this aspect of the matter as well as the
and this is Muslim.
Lordship.
Muslim, then whether the registration and all has any relevance if it is given even orally along with delivery of possession, I think.
That is also completed. That is sufficient.
That is it.
Now your lordship will find this ground number 1, 2, and 4. These are the solid grounds of appeal, your lordship, on substantial question of law at page 7, your lordship. One, 2, 4, and 5.
There is this judgment of the Supreme Court now on this aspect. Exactly on this
Lordship,
point.
that is the
I have
judgment, your
dealt with
lordship.
this aspect earlier in my judgments. 2, 3 judgments I have delivered, where it has been mentioned as to how, I think it was a case where Mr. S.K. Ghosh was a case.
One is 2009 66160. The lordship, in the present case, the donor being a father registered the deed of gift in favor of his son, and they are residing in his house. Therefore, getting the son's name mutated in the revenue record in respect of the gift. So it is complete, your lordship. There is nothing left. Here also, your lordship, during the life of the time of the donor itself, I got my name mutated, your lordship. I applied for loan because I'm an engineer in the ASC. At that time, your lordship, at Bongaigaon, Salaket. So I
So
got
which
my
substantial question of law should we frame?
lordship.
Which substantial question of?
Lordship, which substantial whether the presence of the your lordship donee is necessary, your lordship, for completing the deed of gift, your lordship, or the gift.
Now in the deed of gift, there is a signature out there.
If you deed
In the
of
gift,
your
it is
lordship,
always mentioned now in the gift deed.
It
Down below,
it has been declared, your lordship, in the gift deed itself that I have announced has been accepted and
you have a gift deed?
possession was delivered.
Do you have the gift deed? These are the two gift deeds. Exhibit 3 and 4.
Lordship. Exhibit 3 and 4. Sir.
Show me.
The father has declared, your lordship, that I have divested myself from the
What was your father's name?
Nustibuddin.
Naftibuddin.
Nustibuddin and Tony is Najimuddin.
Nazimuddin. So there is no signature of, he is not a part of the execution procedure.
So this is the gift deed, your lordship. In the gift deed, Nustibuddin has put his signature, your lordship, in presence of witness.
Hmm.
And under the law, your lordship, signature of the Tony is not necessary.
Is it?
It is not necessary, sir.
Why?
Under the law. But in some gift deeds, your lordship will find that as an acceptance, your lordship,
Let us see the transfer of property act.
Mohammedan law.
Mohammedan law is okay. We'll come to Mohammedan law later on. But what does it say about the gift as regards this?
We check, your lordship.
For the purpose of making a gift of an inward, the transfer must be effected by registered instrument signed by or on behalf of the donor and attested by ER. For the purpose of making a gift of a transfer may be effected either by a registered instrument signed as aforesaid or by delivery. Such delivery may be in the same way as the goods sold by way of
So, that is Mohammedan law, section 152.
But the Mohammedan law does not conceive of a registered gift.
Not conceive, your lordship. Mere writing is sufficient, your lordship, on papers, your lordship. Oral gift is permissible, your lordship. Only thing, your lordship, in presence of-
Delivery of possession and having accepted it.
So I have accepted because I have got my name mutated. I have applied for loan, your lordship. I have got it. I have constructed the RCC building also here. I have got mutation, everything, your lordship. During the lifetime that of my father, your lordship, there is no objection. After his death, his different number 1, 2, and 3. So for father is concerned, I have start her name off from the plate, your lordship. Not necessarily still be with me. My sister, different number 3, still used to be with me. But my better, he is actually making up.
Heard Mr. S. Ali, the learned counsel, appearing on behalf of the appellant. the instant appeal under section 100 of the Code of Civil Procedure 1908 is directed against the judgment and decree dated 21/12/2023 passed by the Learned District Judge, Kamrup Metro at Guwahati entitled Appeal number 17/2023, whereby the said appeal was dismissed, thereby confirming the judgment and decree dated 10/4/2014 passed by the Learned Civil Judge, Senior Division number 1, Kamrup Metro at Guwahati, entitled suit number 387/05. The instant appeal is admitted by formulating the following substantial questions of law in terms with section 100(4) of the Code of Civil Procedure 1908. Number 1, whether the learned courts below were justified in dismissing the suit by holding that there was no delivery of possession of the gifted property, whereas on and thereby committing a perversity in as much as the evidence on record, both oral and documentary, particularly of the evidence of PW1, PW2, and Exhibit 3 and 4, showed that there was delivery of possession of the gifted property in favor of the plaintiff. Number 2, whether the learned courts below were justified in dismissing the suit without taking into consideration that the appellant herein, pursuant to the gift bracket Exhibit 4 and 5, have got his name mutated in the revenue records and had taken loan from the Housing Finance Limited of LIC. I think these two is enough.
But any other count should be taken at the time of hearing.
What?
If any other substantive
Oh,
question.
no, there's nothing more.
But
I think these two are enough. With the call for the LCR, list the matter, issue notice upon the respondents. Steps be taken within 3 days by way of registered as well as usual. To list the matter for hearing immediately upon receipt of the LCR and the completion of service. You take this. In fact, there is a Supreme Court judgment exactly on your point. You ask your junior to find out. I have delivered.
Joint family and father makes a gift in favor of a son. Both are dwelling in the same house, your lordship.
No, yes, exactly on that point.
No delivery of person is
Not
necessary.
required. I think that
is there.
that is there in 152 of the Mohammedan
subsection 3.
Yes, Mohammedan law. It says where it is not required.
Lordship, not required at all. This was placed at 2 Supreme Court decisions are there, your
Yes.
lordship, on that point. 2009 and
152.
2007. Those decisions, Patna High Court, that is of the year 1972. That is there in the made.
It was a question like it, whether the learned court below were justified in dismissing the suit without taking into consideration section 152 bracket Roman 3, na?
Not,
It's Roman 3,
no, not Roman. English, yeah.
normal 3
Not normal.
Normal. Of the Mohammedan law, which stipulates. What does it? Which stipulate where donor and the donee both reside in the same property. Whether the learned courts below were justified in dismissing the suit. Without taking into account that the donee, in pursuance to the gift, had completed an overt act, overt act, by carrying out mutation, and also had taken a loan
For construction of an artistic building, which is complete your lot.
and had carried out, taken a loan from a bank to a which in terms with which in terms with section 152(3) of the Mohammedan law, I think to get the service done, these are matters to be finished off as quickly as possible, because unnecessarily the suit has been pending long time. Look it up. Take it a look. Anybody interested in Okay. You sit after 2 weeks.
My lord, some urgency is there, my lord. On the basis of this petition, my lord, the husband is not paying the wife, my lord, for last 6 years. That the marriage was not an valid one.
This is the second appeal.
Yes, ma'am.
So, second appeal, has there been any stay?
No stay, my lord. It is not allowed, my lord. On last occasion, after long hearing, the Honorable Court was pleased to direct them to come with fresh question of law if available. There is no question of law at all.
Let it be. You can very well take action. There is no stay. How is the urgency?
They are taking plea in the other case, my lord.
Mr. Counsel, I will not hear you all if I consider.
My lord, date may be fixed, my lord, kindly on 18th May. Other case also fixed on 18th May. On 18th of April.
What other?
Today in the morning also another case was fixed.
So how does it have any relevance? That's a 2007 case.
No, my lord.
You want to have the consolence that one case is dismissed in your favor and one case is dismissed against you.
No, my lord.
Then?
No, my lord.
After 2 weeks.
I will be out of station for some days. If it comes, I will not be able to.
You have no business today. As of now, you have no business to stay in it. The business will be later on. Once I should admit that. Yes, Mr. John.
I thought the judgment of the Supreme Court matter are the three judge matter.
What is there?
I thought I
like to draw kind attention for paragraph 23 at page 57 of the judgment. Page 57, paragraph 23. Without taking ground of adverse possession, without counterclaim.
Who is the appellant? Amar Kaur.
My lord, yes.
You have filed the suit.
My lord.
Suit for what?
Suit for my lord, declaration and recovery of possession.
For declaration and recovery of possession. As defendant has no right, declaration will be passed in favor of the plaintiff and against the defendant. What declaration you are asking for? Huh?
Declaration.
Where? Where is the prayer? You don't have a prayer for declaration of right title interest. No prayer. Anyway, what do you want?
I thought
What is your evidence you have placed?
my lord, evidence of but my lord, can you see one paragraph of the judgment?
Plaintiff exhibits are revenue receipt, Jamabandi of land Chita. Defendant exhibit Katta so and so. Then
one my lord, 10 paper, my lord, one paper, and that two my lord only submitted, not executed proper
who?
defendant.
I forget about defendant. The plaintiff, what has he done?
My lord, plaintiff executed method is a
Revenue receipts are not documents of title. Jamabandi is not document of title. Chita is not document of title.
Jamabandi method. The Jamabandi is special mention method is a lane was
Those are not documents of title.
right, my lord, but periodic patta where my lord granted.
Where is the first appellate court judgment? Trial court decreed it in your favor.
Yes. Page 43, my lord, transport and one paragraph, my lord. Paragraph 23 of the judgment. Page 57. And 52. That suit was dismissed, my lord, for that finding that adverse position of the defendant, my lord, without plea or without counterclaim. And my lord, vital issue is the issue number 4, my lord, whether the plaintiff has right title interest about the suitland prescribed in the case. Kindly see, my lord, how should have my lord, issue number 4 decided, page 58, page 58. It's not decided properly. No discussion. Issue number 4. Issue number 4, my lord, the main issue.
Understood. That is wrong. Adverse possession is wrong. But tell me what right you have.
That from the Jamabandi matter.
No. Jamabandi is not a document of title.
That's right, my lord, but the right hand side matter, everything matter, based on base matter, that was matter, periodic patta on payment of premium.
So you must be having some
And my
patta.
lord, and my lord,
Why didn't you enclose the patta?
and issue number 4, my lord, can you see that? This is not issue number 4. Issue number 4, my lord, remain issue, my lord, whether the plaintiff has right to interest over the suit. This cited at page, my lord, 58, internal page 15.
Yes.
Taken together, 4, 5, and 6. There is no. There is no discussion at
Issue number
4. At page, my lord, 58. first issue number, my lord, 4 is at page 50, and discussion, my lord, is page 58. So, my lord,
No, why, page 27, they say at issue number 4, he has decided everything.
it could go to the discussion, my lord, issue number 456, at page 58.
No, not necessary.
My lord, this is the vital issue, my lord, right to the
That has been decided. First of all, if you have failed to prove whatever documents it is, then
the Jamabandi, my lord, exhibited, it is clearly, my lord, mentioned by the revenue authority, my lord, is about, my lord, payment of, my lord, premium, about by the amount
no,
of
our Jamabandi is documents of title.
generally not, my lord. But here, my lord, it is the allotment order, everything mentioned, my lord. Allotment order, allotment.
So allotment order, why didn't you get it? Did you try to get it?
My lord, it was protected.
You have. Yes, the trial court is wrong in saying that the defendant have got the title over on the basis of adverse possession. Absolutely wrong. But the fact is, whether you have the title. If you don't have the title, can the question of adverse possession or all other aspects have any relevance? And those substantial questions of law which you have framed are not at all substantial questions of law. Why you are going on the question of defendant? First you prove yourself. Are all these 4 questions have any relevance?
My lord, I have to those document, my lord, the and the Jamabati. And Jamabati is typically my mention everything, my lord.
But those are documents of title, not documents of title.
After this, my lord, it's my lord, Jamabati, it's my lord, the date of my lord, order of the.
Then did you prove? Who are the witnesses to prove it? Plaintiff witnesses are who? Amar Kaur, Chandan Kaur, Joinder Deka, Investor Basumati, Kamal Sharma. Who are those?
My lord, one is Kabuda, another.
What does they say? But have you proved any person from the revenue record?
Revenue, these are not.
Then Mr. Chauhan, you try your luck next month.
Sometime.
The request of Mr. Chauhan, the matter is adjourned instead of it shall submit a fresh substantial question of fresh set of substantial Yes, service is complete.
Yes.
Service complete is the matter for hearing.
16.
It appears. Yes. Why haven't you filed the substitution application? Huh?
But not correct.
Okay. The sole appellant had expired. It was submitted before the court on T1 2024. Under such circumstances, as the period in terms with Order 22, Rule 3 have long expired, the instant appeal has abated, and according the appeal stands abated and closed.
Is it possible?
Acted. Yes,
Lordship, as per office note dated 27/3/24, Lordship, service upon respondent number 4 and 6 has been
what about 5?
5, Lordship, as per office note dated 26/6/23, Lordship, agency left.
Then
Lordship, we have to ascertain it.
no fresh steps have been received in respect to respondent number 5. Then you don't want the respondent number 5. You strike them off. You are not taking service. They are performers. You need them. Unnecessary. Appellant and respondent. Did the respondent number 5 at all participate in the trial? No. They are performers. The learning counsel appearing on behalf of the appellant submitted that the performer respondent number 5 did not participate in the trial as well as also in the appeal. Taking into account the above, the name of the performer 5 struck. The registry shall forthwith take appropriate steps for requisitioning of the LCR. This is the matter for hearing immediately upon receipt of the
Maybe I may very want to have a question. But already we communicated with the appellant as regards the proper address of the respondent number located 2, 8, 3, and 4. Kindly we allow weeks time.
learning counsel appearing on behalf of the appellant submits that he may be given 2 weeks time for taking steps upon the respondent number 2A, 3. This court have duly taken note of the order of the Lord of Court dated 28/3/2020. There were various directions wherein it has been mentioned that in spite of repeated directions passed by this court, no such step was taken. This court have also taken note of the LCR of case number 5 of 2022 have not yet. Under such circumstances, this court grants the appellant time till 5th of April 2020 to take steps upon the respondent number 2A, 3, and 4. The registry shall forthwith take appropriate steps for requisition of the record of LCR of case number 5 of the 2002. This is the matter. This court observes that in the circumstance the petitioner's steps are not received by the registry on or before 5/4/2024. The matter be again listed before on 18th of April 19th of April for further consequential action. It is made clear that if no steps are taken, this court shall pass appropriate orders. 5/4, take your steps.
Office note dated like 3/24, subscription already filed and already
Huh?
submitted. Office note dated 22/3/24, already substituted.
What is that?
Respondent number 1E, 1C, and
Being substituted, the same has been updated date for it. What orders are required?
no, your lordship is
Huh?
ready for hearing.
Is it for hearing?
Yes, sir.
Records received,
Yes, sir.
taking into account that the service is complete.
Yeah.
And records have been received. This is the matter for hearing in its usual course. Yes, what is this?
Lordship, earlier right order dated 5/6/2023, this Honorable Court directed the appellants to take case by way of drafting, and to that effect, an affidavit was directed to be filed, which they have not filed.
What is this? Delay?
Delay, there were 23 days delay in preparing the affidavit.
Are you paying for whom?
I'm for the defendant number 1, Lordship.
You are the main person. Ashok Kumar Borua.
Yes, sir.
Other is who? Opposite party number 2 is?
I think he's the relative of the appellant.
No, this is filed by defendant number 2.
No, filed by the appellant, Lord.
No, it is being filed by the applicant who is the defendant number 2.
Yes.
And plaintiff, you are for the plaintiff.
Yes, sir. Yes.
Respondent opposite party number 1.
Yes.
What about service upon defendant number 1?
I'm the opposite party number 1. That is the plaintiff, Lord. In the I, Lord.
I hope none appears on behalf of the applicant or cause. The office note shows that no affidavit of service have been filed pursuant to the direction passed by 13/2006. This is the matter again on 3rd of June 2024. A further opportunity is given to the petitioner to take steps by way of justice upon the respondent opposite party number 2. It is made clear that if no such step is taken, appropriate order is
Obliged.
Yeah. But the last occasion, my lord, 30/11/2022, my lord, was listed. Now that day, my lord,
Why you are not taking steps?
My lord, respondent number 3, said the respondent number 3 died, my. Accordingly, we have informed the appellant, my lord.
Take first step for notice
my
upon the respondent number 1, 2, and 5.
My lord, they have already died, my lord.
Who?
And 1, 5, and 6, my.
1, 5, and 1, 2, and 5 is what?
My lord, 1 is also died, my lord.
1 died.
Yes, my lord. He
2.
died. He died, my lord. He already died, my lord.
3 died.
5 died, my lord. 6 died, my. My lord, we have collected the details of the legal years, my lord. By this, we are going to file, my lord.
Then when did they die?
The date not provided, but legal years are provided for.
Huh?
The respondent number one died, my lord, on 29/4/2016.
And the phone number?
Respondent number 3, my lord, died 2/6/2021, my lord. And 5, my lord, date is not provided, my lord, but legal years have been provided.
And you have filed against the dead person.
Well, we not filed against the dead person, but
Why not?
subsequently
The phone
came to-
number 1 is dead prior to your filing of this application in 2018.
Subsequently, we came to know it after filing.
So, is dead.
The legal years, my lord,
And in the year 2019, you were given the opportunity to file. We are in 2024, 5 years. You are not interested.
my lord,
Mr. Counsel,
my lord.
you are not at all interested in this. Not at all interested. It is not the manner in which. Why? What is the delay?
Delay, my lord, 10 days, my lord, in filing the only 10.
Then, not interested. You are the appellant.
Appellant.
Plaintiff.
Plaintiff.
To dismiss.
To dismiss, my lord. Appeal was dismissed.
So nothing remains. We dismiss it. Better off. Nothing remains. 5 years. You have not taken steps after the order is passed. You file against the dead person.
We filed some substitution petition, my lord, regarding 1, 5, 6, my lord, 3.
So, unnecessary. How much you substitute, then notice, again another person will die. For 10 days of delay, you are doing this.
By this, it will file.
Huh?
By this, it will file, my
You have not filed till now.
My lord,
Then-
petition is ready, my lord. We have informed to come down to Guwahati, my lord, legal years of that.
Why have you made all these people respondent?
My lord, they with the contested, my lord, defendant.
What was the suit for? Huh? RST contract. I think this is a good case for dismissal. Unnecessary people
Good for
should not
declaration,
be
my lord.
unnecessarily dragged further. That's what is your claim?
Title, interest, and position, my
Okay, now when did Habibur Rahman die? 2016.
I don't. Yes, my lord, 29/4/2016.
29/4/2016. So the decree which was passed against that person, can you substitute now? The decree passed in the first appellate court was of 2017. Tell me, how do you do it now? You are paying for whom?
Respondent number 3 is expired.
Huh? 3.
That's the last of it.
When? When did 3 expire?
My lord,
2/6/21.
2021. 1/6/2021.
2021. And number 4? Number 4?
Number 4 not died, my lord. The phone number
5?
my lord, 5 is died,
When?
my lord. Date is not provided, but date is not.
How will you file then without the date?
The detail here, they have provided the names of detail here, my lord.
Who has provided?
My lord, the appellant.
Then number 6?
Number 6 also not provided. Even my lord, the detail here, details of the legal here could not found. Appellant also died, my lord. I have filed substitution sole appellant, my lord, of his legal.
Appellant also died.
Died, my lord. Legal here, sir, in record, my lord. Filed the substitution petition, my lord. My lord, number is, my lord,
Appellants died.
2659/2019. I am, my lord.
Show me that. Applicants. These are applications. 3082.
No, my lord. 3082, my lord. Substitution in delay petition, my lord.
Applicant was substituted the legal heirs of Tina. When did he die?
Uh, 2659.
19. You filed when 19.
Right.
So this is on time.
My lord.
Then the other one is what else?
That one also, my lord, in time,
Only
my
one. So we allow this application, huh? And why is this 2659?
2659, my lord, substitution of legal heirs of the appellants, my lord, in arrest.
So these two are same.
Yes, my lord. Ultimately same. I think one in RSA, one in.
This is an application under Order 22, Rule 2, Rule 3 of the Code of Civil Procedure for substitution of the legal representative of the appellant who expired on 14/4/2019. The instant application was filed on 28/6/2019. Taking into account the statements made in the application that the right to sue survives upon the legal heirs, legal representatives of the deceased appellant, this court simply substitute the applicants of the instant application as the against the name of the appellant. The registry shall make necessary changes in the cause title on the basis of the instant order, and the petitioner, applicant, the counsel for the applicant shall also submit a fresh memo of party. এখনো থবো আৰু এখন আছে, this is 2659 2018 আৰু এটা আছে 3082 of 2018. 3082. Yes.
During this IA, my lord, pending, my lord.
Another person died.
Appellant's number 1, mother, my lord, died. So, my lord, her name may be described. The mother.
3069 is for what? In the IA, na?
3082, my lord.
3082 is in IA.
IA, my lord, in IA.
IA could be 82 for yeah.
Correct.
3082 IA. It is the application. 3082. Against the because 2659 are to that during the course of the hearing, it has been mentioned that the applicant number 1 had also expired during the pendency of the instant application. However, the estate of the applicant number 1 is duly represented, and as such, the applicant number 2 to 5 are substituted. Against the name of the applicant appellant. Substitute as applicant number, appellant numbers 1, 1, 1, 2, 1, 3, 1, 4 in the appellant numbers applicant number. This is the matter of after 2 months. Take your step, whatever it is. Otherwise, we are going to. But one thing, you have a problem. There is a dead person. Person has died out there in the street. How do you take care of that? How can this court substitute against the dead person? The decree which have been passed at that point of time when the person is dead. Yes.
So, official dated 19/20/20. It is service upon the respondent to its it could also receive.
This is for what? Condonation of? Condone. Now, what is that? RSA for what? RSA has been substituted. Then what? Why the matter has come up?
Notice about the respondent 2 was not
complete. Service being complete and the LCA having been received. This is the matter for hearing.
Please, your lordship.
Yes, you have taken steps by way of paper publication.
No, my lord, you financial constraint, my lord, they could not take the steps, my lord. May I say, DRME action actually by it was directed to be published on 23/11/2023, my lord. Due to some financial constraint, they could not because cost was coming around 65 to 70,000 for publication. Now they said they would be able to publish, my lord.
But where have you filed an application?
I was filed.
You filed an application. You took an order, but then also you have not.
No, after filing of that, my lord, due to some financial constraints, they could not.
Then the order having not been found, it ordered.
That is closed, my lord.
No, we'll pass an order. Don't worry. No. We stop you from doing it. This court, by an order dated 25/9/2023, directed the appellant to publish in Assam Tribune and Dainik Janambhumi on 23/11/2023, thereby fixing the matter on 28/11/2023. The same direction was given on an application filed by the appellants. However, the appellants have not taken any steps in that regard. Consequently, we proceed against as if there is nothing.
My lord, I pray for some.
No.
For 1 week time, my lord.
No.
Because of financial constraint, they could not, my lord.
We can't happen like that. Taking into account that no steps have been taken.
No, my lord, 1 week time may be given, we'll publish, my lord. One week time may be given, we'll file a separate application for.
We can't do that. Taking into account the above, how many respondents are there?
Sole respondent, my lord.
Then against the sole respondent, you have not been able
No,
to.
my lord, actually, that is why I'm submitting, because of financial constraint, they could not. The cost was coming around 65 to 70,000. That is now, they said they now.
Kindly see, at present they are at Bamuni Muidam.
No, my lord, they are also, notice was returned from there, also. That is, I pray for 1 week time, I'll file a fresh application.
I'm not going to say anything. Taking into account the above, list the matter.
One last chance.
Is there a stay?
No, man.
Oh, we have framed substantial questions of law.
Yes.
So we dismiss the appeal right away.
No, my lord.
No.
I pray that, my lord, because
No,
of
no,
their
no,
financial condition, they could not.
Taking into account that the service have not been complied with, nor steps have been taken against the respondent, this court is not inclined to proceed with the instant appeal. Accordingly,
My lord, 1 week time may be given, my lord.
I can't. You have not taken steps
No, my
by
lord,
yourself.
That is why I'm saying, my lord, because of the.
Stay order, Asani.
No, man, no separate.
Oh. There is an execution proceedings.
No, man.
Why there is a mention of Order 21, Rule 97?
So it is of earlier suit, my lord. An earlier suit was filed. Of 2000.
Taking into account the above, this court, taking line to like it, have not taken any steps in pursuance to the said order passed by this court. Full Mr. S.K. Chakraborty, the learned counsel appearing on behalf of the appellant, further seeks an opportunity to make publication. Full stop. Taking into account that there has been no steps taken pursuant to the said order, this court cannot enlarge the period unless a fresh application is not filed. Full stop. Accordingly, the matter be listed only after an application is filed by the appellant for paper publication. Hey, I'm to green book or Turkey book. Next time, he doesn't get.
The matter pertains to my lord, and the matter is settled, already settlement.
Settled?
Yes.
Yes, in medicine.
Okay.
Lord, order
The learned counsel appearing on behalf of the parties submitted that the matters have been amicably settled in terms with the report of settlement, which have been made a part of the instant record. Good stuff. Where is the report?
My lord, 46,020.
Accordingly, the instant appeal therefore stands disposed of in terms with the report, in terms with the agreed terms and conditions which agreed terms and conditions which form entered into between the parties on 14/6/2023. Full stop. The said terms and conditions shall form a part of the decree of the instant P. The registry shall prepare a decree in terms with the said agreed terms and conditions dated 14/6/2023. Please record. Appeal stands accordingly. Yes.
I'm on behalf of Esther.
Service complete.
Yes.
Service complete leaves the matter for hearing in its usual course.
And 26 matter. There is the service complete and that is.
So service complete.
Yes.
Service complete.
Correspondent.
All.
All.
Okay. Service complete and lists the matter for hearing in its usual course.
No, record has not come. Record.
LCR received. LCR.
My name has not been shown.
Go to the registry. Yes.
27.
Take a order. Same order. Huh? Service complete. List the matter for hearing in its usual course. Service complete.
Yes, my lord.
Service complete.
Yes, my lord. However, my lord, respondent number 1 has died.
Service complete. List the matter for hearing in its usual course. Whatever may be, somebody died. What do I do? When did he die?
My lord, died.
8/9/2020.
20?
23.
And he's the main one.
Yes.
These are the others are not important.
Others, they are performer.
Others are performer.
Yes.
Okay. It has been brought to the attention of this court that the respondent number 1, who is the main principal defendant, defendant,
Like he was the plaintiff in
the plaintiff who was a plaintiff, had expired on 8/9/2023.
Yes.
So no further steps have been taken in pursuance to the said. Accordingly, the instant appeal stands abated and closed. The
Please, your lordship.
Yes.
Lordship, on the last occasion, the case was almost about to dispose of, but it took time for filing one affidavit. This affidavit is not yet filed.
Oh, that one.
My lord.
Yes.
My lord, the matter may be disposed of today, my lord, to giving one opportunity to the petitioner. That the matter is transfer petition is family court matter. That the petitioner is wife. Wife, she is deciding it in Jorhat matter. It's a superintendent of tax. Assistant superintendent of tax. Deciding the Jorhat. So the matter is the guardianship case which is pending before the principal the family court Guwahati. So matter is that my lord in family court, my lord all matters are taken camera in
Huh?
matters are
In camera.
In camera.
So
there is advocates are not there. And it's an advocate my lord with presence of the parties presence of the parties are not.
Yes.
Presence of the parties are. So my lord the petitioner wife is in Jorhat. So it is very difficult for her to appear in person on an ABT date matter. Family court Guwahati. But if observation is given that she may be allowed to contest the case on virtual mode, video conferencing.
You ask them that you want to do it virtual mode. If they don't, then we'll see. Can they say today, can any court in India say that we are not going to give you by virtual mode. No. As of now, no. You tomorrow ask for virtual mode, I will have to give it. So under such circumstances, let him ask them. Withdraw. The learned counsel appearing on behalf of the petitioner submits that he would not like to press the instant proceeding. He, however, submits that taking into account that the petitioner resides at Jorhat and presently is working as the
Assistant Commissioner of Taxes.
Assistant Commissioner of Taxes. It would be difficult on her part to be present on each and every date before the learned family court. So he submits that he may be permitted to, the petitioner may be permitted to join in the virtual mode. So this court have given an anxious consideration to the said submission. It is the opinion of this court that such a request should be made before the learned family court, where the matter is pending, and the court shall duly consider the same. If possible, as per its infrastructure. In view of further to that, in view of the withdrawal of the instant application, the instant proceeding stands closed. The court of the Principal Judge Family Court number 1, Kamrup Metro at Guwahati, shall proceed with the adjudication of Miss Bracket Guardianship case number 153/2022 in accordance with law. The parties, in view of the state suit, further to that, this court vacates the interim order dated 17/5/2020. This court, further to that, this court further observes that by the order dated 15/3/2024, the interim order passed earlier was not extended, was vacated by this court. However, taking into account that the parties are duly represented, the parties are directed to appear before the trial court on 2nd of May. Yes.
Complete in this case. Office note 93/24.
Yes, what has happened? Service report on so and so received, LCR received. Served received by so and so. Have entered appearance on so and so by what? Service complete. Service complete, LCR received, list the matter for hearing. Yes, respond number 3 not found.
My lord, it's not coming, my lord, is a pro forma.
You don't want.
My lord, not main respondent has appeared.
Okay.
My lord,
The learned counsel appearing on behalf of the appellant submits that respondent number 3 is a pro forma respondent who have neither contested the suit. He is not contested, na?
not contested. 3 and 4.
Respond number 3 and 4. No, respond number 3. Pro forma respond number 3 is have neither contested the suit nor submitted any written statement. Taking into account the above, the name of the respond number 3, pro forma respond number 3 is struck off. Further to that, this state court having taken note of that the respond numbers 1, 2, and 2 are duly represented and the LCR have been received, list the matter for hearing in its usual course.
I'm appearing for respondent number 1 to 11. Office note indicate that my lord notice my lord upon pro forma respondent number, my lord.
Mr. Islam, we have it, do one thing, we'll have it some other day, taking into account the 16, 19, 21, and 22 had expired. So let us take it up on some other day. List the matter again on 10th of April, on 22nd of April. Yes, what is this?
This I filed for restoration of an I.
No substitution application has been received in respect to respond number 4A and 4B.
Yeah,
What do you want? Mr. C. Sharma. Did this matter come up on that day?
Yes, yes.
And that is a 10 days or 11 days of delay.
11.
You were not well. I adjourned it. Okay, now tell me. This is a case by which it should be dismissed. I remember.
In that I
Or you are still not well today.
But in that I also we would like to amend our petition that I.
Why?
That delay has not been extended.
Then there is not a single whisper. Okay, Mr. C. Sharma, appearing on behalf of the applicant, submits that he may be permitted to file an additional affidavit. List the matter again on after 2 weeks.
Okay.
Yes.
That matter was dismissed on 10/3/2020.
Exploration. Who dismissed? Oh. Okay. I agree. When did you file that? Who I with a stay. Delay. 136 days. So we'll have to issue notice. Because IA 2646 that notice করে দিব আৰু miss case 68 notice করে দিব এই দুটাতে press steps steps be taken by way of real notice registered by 4 weeks returnable by 3 days steps registered as valid. You can to take the matter again on 19th of in the section of no steps. The no step together in the category of no step. 38. Within time?
My lord.
Within time?
Yes, my lord.
Order 22 rule 3?
Yes, my lord.
When did a person die?
My lord, 31/5/2023.
31/5?
2020.
31/5/2023 to file it on 14 days. This is an application under Order 22 Rule 3 of the Code of Civil Procedure 1908 for substitution of the legal representatives of the appellant who expired on 31/5/2023. taking into account that the right to sue it has taking into account the statements made in the application as well as the submissions of the learned counsel for the petitioner appellant. Right to sue survive upon the legal representatives pursuant to the death of the appellant. The instant application stands allowed, thereby substituting the applicants herein against the name of the appellant and arraying them as appellant number 11, 12, 13, 14, and 15 to the accompanying second appeal. I stands disposed. The counsel appearing on behalf of the appellant is directed to file a fresh memo of parties before the registry of this court, and the registry shall, on the basis of the instant order as well as the fresh memo of parties, make necessary correction in the cause title of the accompanying second appeal, and also update the same in the CIS. I stand disposed. The said memo of parties, the state amended memo of parties be filed by 5/4/2024.
Most of it. My lord, I am the appellant here. My lord, application has been submitted at order 39, rule 1 and 2. My
You have
lord,
filed your objection?
I have received the copy, my lord. I will file objection.
You have filed?
No, my lord, I will.
The
Sometime
same
will-
submission was made by you on the last occasion, Mr. Lai.
No, my lord, at that time copy was not happened.
Mr. M.A. the learned counsel on behalf seeks for an accommodation for filing reply.
My lord,
That was given
here-
on 18
here we
2024.
only received copy on 27/3.
27?
3.
You gave it later?
Yes, ma'am. Copy.
Okay. Mr. M.A. the learned counsel appearing on behalf of the respondent submits that although on 18/3/2024 he had submitted that he would like to file a reply, but as the copy was served only on 27/3/2024, he could not submit the reply within such a short span of time. He therefore seeks for another 3 weeks for filing. It's the matter again on 29th of April 2020.
Your lordship.
Yes, what is this?
Petition is being preferred against the order dated 6,020 passed by the November 14 W3025 of 2021.
Where? Where is my order? What mistake have I done?
Reference at page 16. Page 16.
Berlin Kumar Sharma. What did I do? What is the mistake?
Your order is at page 17.
Huh?
Your order is at page 17.
What is wrong?
Dr. Factory on the date of hearing of the matter of the Directives counsel engaged by the petitioner did not appear before the court. With some fact of the case, it would the other giving the outcome.
So, you don't care to appear on the last occasion, what do I do? What have you challenged? Challenging the decision of and rejecting the technical bid of the petitioner on the ground that the scanned technical bid was not attested by the petitioner, that is the bidder. Then, Now what has happened? The work completed.
Oh, that thing, sir, I don't have it.
I'm technically here, na?
Yes, sir.
Then
That he was participated in the tender process and some there was mismatch in his document, Lord.
Madam will do one thing.
You were qualified on the
Madam will do one thing. We will have it on 23rd of April. You argue whatever you have. I'm not issuing notice. If you have a good case, I'll issue notice. Otherwise, the fate is known. Okay? List the matter on 23rd of April 2024. What important and on which date? Mr. Tisham appearing on behalf of on the next date, Mr. C. Sharma appearing on behalf of the Water Resource Department, please, as regards the status of the project, the contract.
51.
Yes, what is this?
May please, your lordship. My lord, otherwise, my lord, the service is not complete, my lord, or otherwise, if you, your lordship, because the hearing will take some time.
Hearing,
Or
I did not extend the order on the ground. There must be a good, very good reason. Why didn't I extend the ground? You asked for something, na?
Yes, my lord. I am ready with that point, my lord.
Yes, please be.
My lord, the petitioner, my lord, they were in possession of a certain plot of land, my lord. Whether the adverse possession is will be established or not, that is a different separate aspect, my lord. But otherwise also, my lord, the way, my lord, the respondents have...
No, I remember. You have been evicted.
Yes, my lord.
You are no longer there.
My lord, there is a process of law, my lord. By a process of law, my lord, even a tenant can be evicted, cannot be evicted without following process of law. With the muscle power and manpower, my lord, they cannot evict a person from the possession of a particular plot of land, my lord. So on this ground, my lord, there are several judgments of the Supreme Court as well as this honorable court that, my lord, when a person has to be evicted, they have to follow certain procedure of law, my lord. And in my petition, I have categorically stated, my lord, till what date, my lord, she was in possession and on what date she has been forcefully evicted from the premises, my lord. If your lordship takes the page 101 of my appeal, my lord, page 101, there are 16, my lord. It has been stated in the plaint, my lord, that the Paramananda purchased title B land on 1963 by LD number 20 in the name of defendant number 1 and father of defendant number 2 and 3, who appears to be two owners in record, but they never came to recover the title B land. As such, the right title and interest, whatever was got on the strength of the state sale sheet bearing number 20 and 20 become adverse in favor of Paramananda Borwa due to continuous possession with effect from 1963. And the possession became adverse in favor of Paramananda on 19/7/1975, and for continuation of adverse possession for another 12 years without interruption, as such the title of Harinayan Bora and Dhojanayan Bora became adverse on 19/7/1987. Accordingly, the title of Paramananda was perfected 60 his death, and on his death, the title on the state land of Paramananda inherited by the plaintiff and pro forma defendant. My God.
We'll have it on Thursday.
Yes. And my lord, the
But is this court taking up this appeal now? I'm not taking up appeal. Appeal is being taken up by another. did the matter on
Because my lord,
Thursday.
obliged, my lord.